Okay, let's get started. My name's Jim McCloskey. Today we are in Colorado Contracts and Regulations. This is lesson 5. Let's go into your book and go to chapter 4-1, and this is subdivision laws. And let's skip over to 4-2. 4-2. Bottom of the page. Subdivision statutes. Look at 3A down here toward the bottom. It says subdivision means any real property divided into 20 or more interests intended for the residential use and offered for sale, lease, or transfer. These only apply to condominiums, co-ops, and timeshares. Condominiums, co-ops, and timeshares. It does not include single-family properties. And again, it's 20 or more units, and it has to be registered with the Real Estate Commission before you can start developing. You will have a couple, 3 questions on this. And the main thing is, it's not for single-family homes, and top of page 3, campgrounds. For selling of membership in campgrounds. We talk about this particular law several times in the course. And again, it's a very unique law, kind of obscure law. And again, if there's going to be 20 or more units for condominiums, co-ops, and timeshares, it has to be registered with the Real Estate Commission. I had this RV park we were going to do up in Loveland. In fact, it was Johnson Corner. Johnson's Corner, we were going to be in partnership with them. They were going to contribute like 250 acres, and we were going to develop it. And so we're getting everything ready, and I went down to the Real Estate Commission to get it registered. And Lydia Cruz, who was the head of subdivisions at the time, I hadn't seen her for a while. So we got into the conference room and got caught up a little bit. And she said, "So, what are you here for?" And I said, "Well, we're doing this RV lot up in Loveland, and I came down here to register it." And she said, "You don't have to register campgrounds." And I went, "Wow. That's what a campground is, like an RV lot. I've been teaching this for years, never knew what a campground was." So that's an example of a campground, like an RV lot. And this is, like I say, you're going to have a couple questions on the state exam. Don't go into a lot of brain damage about it. There's not that much to it, except that there's 20 or more. And it's for condominiums, co-ops, or timeshares, then you do have to have it recorded before you start developing. Now, let's talk about these things. Just run through it again. What is a condominium? Who wants to tell me? I'm brand new. It's an air lot. That's a good start. What does that mean? You only own the air inside your unit.
You don't own the walls, the
You
ceiling.
don't own the walls, the ceiling, or the floor. What else don't you own? The land. The land or the clubhouse or the swimming pool or anything else. But everybody in the whole subdivision owns all the exterior walls and all the land and the clubhouse and tennis courts as tenants in common
with an undivided interest.
with an undivided interest. What did that take? A minute to say? How impressive is that when your people ask you about a condo and you know it like that? Pretty cool. So what's a co-op then?
By share.
Nobody owns.
It's a corporation.
Picture a condominium, 4 or 5 story building, but it's owned by a corporation, and you don't buy the individual units.
Yeah.
You buy stock in the corporation equal to the value of those units. And because you're not buying real property, you're buying stock. You don't get a deed. You get a
Preferential lease, what's it called?
begins with a P.
Proprietary.
There we go. Proprietary lease. You don't get a deed, you get a proprietary lease.
The next one you take the test.
So that's the main difference between a condominium and a cooperative. You see these co-ops on the East Coast and up in Washington State. There's one in all of Colorado. On the Colorado portion of the exam, we have no questions on co-ops at all. On the general portion, you're going to have questions on them, on the national portion. And you should nail them, just what you told me. You should nail every question they have just by that. Again, the main one is, and that you will have, is that you don't get a deed, you get a proprietary lease. Right, right. Okay, let's go to page 4-20. 4-20. 420.
Proprietary lease.
Marijuana laws.
At my age, you think I wouldn't do it?
Proprietary lease.
I think people our age and better do. Bottom of page 420, guys. Licensee's responsibilities. Let's read this. A real estate licensee cannot be expected to be completely familiar with all county and municipal planning laws, regulations, ordinances, and zoning requirements. I like that. They're my least favorite word. However, which cancels out that whole thing. However, the licensee in negotiating should be very much aware of the existence of these laws, ordinances, zoning requirements, etc. It is very easy to misrepresent property through ignorance. If uninformed, the licensee should seek the information from the proper source before making a representation, or refer prospective clients to the proper source of the information. Some facts should be known to the licensee through reading or logic, such as the sale of a portion of a seller's land divides the land into two parcels, and a subdivision is created that must be approved by the proper authorities. A subdivision isn't necessarily where you divide it up into 20 separate parcels like we just talked about. Taking a piece of ground and cutting it in half subdivides it. That's the definition of a subdivision. They're going to try to get you on the state exam by playing games with that number 20 when it comes to subdividing. Don't let them do it. Don't let them do it. We're going to have all kinds of questions here in class that'll help you get around those. Look on top of page 21. If a structure is suitable for conversion into a duplex and or a fourplex, it does not in itself mean that such a conversion does not violate the law. So again, just because it's zoned for a certain way doesn't mean you can necessarily do it. And this comes with experience and mistakes, learning how to do these. There was a flip that I did one time. It was down right around by Loretto Heights, actually, in Denver. Denver's is the easiest city of all to do flips in, usually. And what happened, I really liked this lot because it was like 100 feet wide, but it was half an acre. It looked like a football field, and it was zoned where you could have two duplexes on it. And I thought, man, this is going to be wonderful. So we figured out, put some dollars, put a pencil to it. Huge profit margin, the whole bit. And what happened, I was the money guy. Then I had a partner who did all the work and everything, and all of the sub contracting and everything with everybody. I told this story a few years back, and I mentioned I had a partner. It went all through school that I was gay. That's not the kind of partner I had, okay? It was strictly business, okay?
There's anything wrong with it.
Anyway. So what happened is we're looking at this property, and there was this old beat-up house on it. We were just going to tear it down. It was a hunk-of-junk house. And Scott kept going downtown to get the building permits and everything, and every time he went down there, he got a different story. And after close to a month, we hadn't done a darn thing. And, we said, man, we got to do something with this property. It's called a fix and flip, not a fix and drag. You got to sell that sucker. And so we thought, well, let's go look at this house and see how bad it really is. And so what happened, we walked in the house, and it was one of those bungalows where you walk up and looked over the right here, and there was a living room there. And this living room was full of trash. In fact, one of the toilets was sitting out in the middle of it. It was really bad news. And Scott, actually he was my ex-son-in-law. He was one of the top people on my staff in my appraisal company. And my middle daughter begged me to set her up with him, introduce him. So I did. And they ended up getting married They were married for about 10 years. Now she's doing everything she can to destroy his life. So nothing new there. Anyway,
It's his first
Damn women.
marriage comic this week.
first marriage
First one
comment?
this week, yeah, last
Yeah.
one was
First
full
one
of
this whole week?
Yeah.
Well, I'm slipping.
I've been
Sorry.
carrying you all
I've been
week.
watching.
You guys. Now, what happened? And so Scott goes walking through the living room and fell through the floor into the basement.
No.
And I'm going, we're in trouble. We are really in trouble on this thing. I went downstairs and he was okay.
Terrible.
Durable, yeah. But what happened is that whole basement was full of trash, and that's how you got around. You got between the piles of trash and walked around. And very poorly built. Very poor. It's just as cheap as can be. And in the way back corner, that's where there was only about 4 feet of trash in there, except in the corner where they dug out, and that was their bathroom back there. I mean, it was bad, really bad. Scott ended up filling 2 of those huge dumpsters, and it took him almost 2 weeks to do it. And he said the worst part of it was all the dead animals he found down there. The dead birds and rats and snakes and everything else. He said many times he just had to go out in the backyard and just lose it, And then we were ready to get started to build it, and at that point, I felt fine because I was so busy those 2 weeks, I wasn't able to help him a lick. I really felt bad. But he finally got it all done and we started doing that house. Amazing. This guy had more talent. When he got done with this house, it was in new condition. And he went out and put the sign out in the front yard, and when he put the sign in, some guy came by on a motorcycle and made an offer on it. We didn't close that deal on that offer, but we did soon afterwards. And we still made a couple bucks on the deal. Nowhere near what we could have made. But again, everyone is different. Just because it's zoned for something doesn't mean it's automatic that you can do it. Knowing how to play the game. And like I say, there's only one way to learn. Mistakes. Wish there was a better way. Let's keep going, number 3 here. If an area is zoned for keeping horses, it does not necessarily follow that the acreage of the property is great enough for this purpose. I've seen homes in Lakewood where you've got just a regular home, regular sized yard, and there's a horse out back. I tell you what, it breaks your heart.
Aren't you supposed to have at least 2 acres for a horse?
No, not at
Not
all.
here?
Not at all. Not 2 acres minimum. Not at all.
Well, in Indiana, they
You're
You
supposed
should.
to, but you shouldn't.
You should.
do. In
Yeah.
Indiana,
Just
they'll
for
take your horse.
humanitarian purposes, if nothing else.
They'll take your horse if you don't have at least
At least 2 acres in
for
Indiana.
each horse. Yeah.
Indiana. Oh, wow.
Per horse. Wow.
Per horse.
That would
Per
be a
horse.
lot.
2 acres. Really?
That's huge.
Wow. Well, I tell you what. I tell you what happened in Park County about 10 years ago. And Park County runs from Conifer all the way down to Buena Vista. I mean, it's a big county. And they came out with this law where you had to have a minimum of 5 acres to have a horse. But they grandfathered everybody who has a horse right now. And it caused nothing but huge problems with real estate brokers who didn't know this law. So people were looking for horse property, and you drove up and said, well, of course it's horse property, there's horses here. And the people would buy it, and a couple weeks later there'd be a knock on their door, and they had horse police going around and telling people, you got a week to get these horses off your property. And it was just a heck of a mess up there. As far as I haven't heard any more complaints lately, but it's got to probably still be. So again, just knowing what the rules are, knowing what the laws are.
So Jim,
Yeah.
you would look at either covenants, PUDs, and county zoning for something like that?
Would you do it? No.
No,
What you
but-
who's
but
going
the
to do?
buyer
You would-
would-
Who's
you
going to
would
do that
guide
for
them
you,
to
Natalie?
those.
Who's going to do that for you?
The buyer is
The-
going to
The buyer better,
Title company.
probably, but the title company.
title
The
company.
title company's going to check that out, and that's going to be part of the title.
Well, there's a subdivision near us that's having big discussions because the PUD and the covenants are at odds with each other on a lot of those things.
Well, when there's an odds between the covenant and the what's a PUD?
Public
It's a small
Public Utility District, and then you have also what else? When you have a homeowner association,
De minimis PUD.
A PUD, planned unit development, two different things.
Right.
Are you talking about a PUD
I'm
or?
talking about a PUD.
Well, PUD, okay, two different things, guys, two
PUD,
different things.
sorry.
No, that's okay, that's okay. But remember, if you have zoning and all this other stuff, then you have a PUD. The PUD includes all of the zoning plus the private laws. So the homeowners association, what are some other words for those documents? Homeowners association documents, bylaws,
Governing.
CC&Rs. What the heck's a CC&R? What's that stand for? Covenants, conditions, and restrictions. CC&Rs. Covenants, conditions, and restrictions. What are some other words?
CIC.
CIC, which stands for Common Interest Community. All these are the same thing, guys. Again, bylaws, CC&Rs, governing documents, not government documents, governing documents.
Which one was that?
Pardon me?
What did you?
These are all homeowners association documents, different names for them. CC&Rs are covenants, conditions, and restrictions.
What's POA? I seen that on a land listing.
POA,
I didn't know what it was.
Ponies of America.
Yeah.
and every county can have their own descriptions too. It's usually some type of planned ordinance in there for some reason, usually. But again, all of these usually private, and they're stronger than the zoning because they include zoning. Typically, that's why I'm surprised, Natalie, that they're arguing with each other, because the zoning is always going to be less obtrusive than the PUDs, than the planned unit development, the homeowners associations. The deed restrictions, that's another name. Deed restrictions, CIC, Common Interest Community Documents. All of these things are the same thing. And they're the most restrictive of any restraint on a property. And this number 4 is interesting. Even if an area is zoned for a home business, there may be a prohibition against employees. What if this lady you're taking around wants to put a salon in one of the bedrooms? And you check the zoning, and the zoning says, cool, you can have one in your property. So you sell it to them, and then a month later the homeowners association tells them they can't. They can't. And what's our liability in a situation like that?
None.
Virtually none. Because they've signed a statement saying that they read the homeowners association documents and agree with them. They also signed a statement saying that they read everything about zoning and issues like that, and they agree with it. So because of that, we're very well protected. We're talking about this. Let's go down to bottom of this page. Second to last paragraph on that page where it says, sections of the state statute authorize the creation of a municipal planning commission, which must make or adopt a master plan. Above that, put down comprehensive plan and master plan are the same thing. Before I can start building this property, developing this land, I have to have a master plan or a comprehensive plan that has to show a whole bunch of things. Look at this last paragraph. Let's read this last paragraph here. The zoning commission must approve subdivisions. Developers who sell land from an unapproved subdivision are subject to a financial penalty. And the zoning commission may also highlight that word enjoin. That means stop. Enjoin means to stop. We're going to study that word in great detail over the next day or so. Enjoin means to stop, and if you don't remember that, there will be a question or two on the state exam you'll miss. No two ways about it. If you don't remember what enjoin means, that's Latin for stop. Let's look at page 422. What's part of this planning department, this comprehensive plan, this master plan? Look at the middle of the page where it has number 1 there and right above it. Let's read this number 1, right above number 1. Subdivisions must submit the following information to the county authorities before sales within the subdivision are made. We have surveys and ownership, site characteristics such as topography, a plat showing the plan of development, and plan of the completed development, estimates of the water and sewage requirements, streets, utilities, and related facilities, and estimated construction costs, evidence to ensure an adequate supply of potable or potable, however you want to pronounce that, water, and dedication of areas for public facilities. Upon request of a complete preliminary plan, copies will be distributed to 10 interested public agencies for recommendations. An approved plat must be recorded before any lots are sold. No plat will be approved until the subdivision has submitted a subdivision improvement contract, agreeing to construct the required improvements, accompanied by collateral sufficient to ensure completion of the improvements. And there again, that's all part of being a developer. All part of being a developer. Okay, let's do this. Let's go to chapter 5 on page 4-25.
I don't have a 425.
Oh, you don't. 5.1. Yeah. I just seen you were paying attention here. It looked like 425 without my glasses. What can I say? Now, what this talks about are CIC's common interest communities and common association manager licensing programs. We've talked about it now, where if you're going to manage a homeowners association, you have to have a separate license to do that. And this just came about in 2015. It's a brand new law, guys. And it's a brand new income source for you if you want to take that route. You don't need to have a real estate license to get this. But to become a homeowners association manager, you have to take what's called a CAM class, Community Association Manager class. And you can take it from us. And there's only 2 schools that have in-class studies for it. The other school that does it, they charge $695 for this class. We charge $460. And if you're a student here, we charge you less than that.
Let me be back now. Sorry.
I'm telling you, yes, and it's going to be on Fridays and Saturdays. It's only 24 hours. Friday, and Saturday, and you've got another designation to your name, another income stream. Some of you should really consider this. A lot of times your salary is half of whatever that association is bringing in. And if you're sitting on the board of directors, you usually get a salary besides. And many times you get a free place to live. Wow. So if you're interested in that, come see myself. Actually, Lauren's one of the instructors on it. You can talk to Lauren too. Are there any questions about that? And
I don't really understand how it works 100%.
You don't understand what?
What is it?
Again, if you're running a homeowners association, you're the president of a homeowners association or the manager of a homeowners association, you have to have a separate license now.
Uh-huh.
Before you didn't, now you do.
But can you still do real estate?
Oh, sure.
Oh, okay.
Sure you can.
Are there size limitations or requirements? If it has to be below a certain size, you don't have to have such a person.
Well, what they say, if it's so small you don't need one. My cousin, weird cousin Joe. Every family has a weird cousin Joe. We do. Anyway, but Joe is the president of his association, but it's so small they don't pay him anything. You know, they pay him $100 when it snows and he shovels the walks or something. But because he's not on salary, he doesn't have to be licensed for this. But you know, any good-sized homeowners association, there's one big one down in Aurora. They've got 15 different managers. You know, and in Colorado, there's over 8,700 homeowners associations.
So what kind of things would you do? Just like make sure the grass is cut. Make sure.
No, you're the manager of the
That's what I'm
homeowners
saying. You make sure
association.
you find
Yeah.
the people to cut the grass.
No,
you
no. You're renting the units out. You're getting the people in to clean the place. You're not doing anything. You don't do any physical work.
So
You're
it
hiring all
wouldn't
that
be
stuff out.
single-family residents.
What's that?
It wouldn't be for single-family residents, like,
It could be for single family. You bet. The homeowner association. Oh yeah,
But they
very
gotta-
much so.
they
they
gotta-
pay
they
my
gotta
mortgage?
Well, they pay your mortgage. You bet.
If you're the manager.
Yeah. Huh?
if you're the manager. But they're the ones that take care of the grounds for the shared interest areas, right?
Exactly. All these buildings that are being built, guys, you can't go down a street anymore without seeing a building going up. Every one of those is going to have a homeowners association, and every one of those needs a homeowners association manager.
So I would just show up and say, hey, look at my credentials. And
You'd show up and say, I'm a licensed community association manager.
How long do they have to comply? Because you mentioned last week there's way more HOAs are gonna need these people than there are people now licensed to do it.
Tremendous shortage, because a lot of these people don't even know they have to be licensed. It's been a heck of a mess. The Real Estate Commission figured between 5,000 and 15,000 people would have to get licensed. Less than 1,000 have gotten the license so far.
there's only 2 schools that do it, you said?
The only 2 schools that do it in class. Yeah.
Is there a time limit for compliance for these HOAs?
Is there a time limit for compliance? Yes, it was last July 1st of 2015.
So we need to all take the class, then report every single one of them, and
That's
then fill
right.
their place.
I'll tell you what, guys, this is could be a nice little side income for you guys. Not only that, but when you're working those associations, you know, especially if it's a rental place, you know when these leases are ending, so you can talk to these people about getting houses. I mean, come on, this could be a tremendous asset source for you. So something to consider now. And you have to wait till this course is done? I wouldn't. I'll tell you what, this book does an exceptional job on property management. And it gives you a real good start on what to look for. To be a property manager, you have to have a real estate license. That's different than being a manager of a homeowners association. 2 completely different functions. So anyway, if anybody's interested in this, do give us a call. We'll be glad to work with you on it and get the ball rolling
Didn't
for
you
you.
announce there's like 50% off or something?
I won't give you 50% off. I'll give you 50. I'll give you close to 50% off of the $690 the other one's charging.
Well,
Sure.
And if you pay cash, it's 10% more.
10% more if you pay cash. Yeah, I like that. Let's do this, guys. Let's flip over to page 5-79. 5-79.
Wow.
That's one way to get through this book. 579. Several years ago, I had this one property, and it was say about a $300,000 home, and my association fees were $6 a month. All they paid for was to have some kid pay for the sign up front and pay for some kid to mow the lawn around it. But let's say I didn't pay my association fees for a year, and I owed them $72. And they're so upset, and they come and knock on my door, and they say, we want your $72. And I say, you know what? I'm not in the mood. Come see me when I sell the home. You can have it then. And they say, well, we're going to foreclose. I'll say, well, go ahead and foreclose. That'll make you liable for my $250,000 first mortgage, my $30,000 second. So you take the responsibility for $280,000 worth of debt, and you can sue me and get my $72 I owe you. Well, obviously that would never happen. What would happen is they changed the laws, where now homeowners associations are paid right after taxes. Right after taxes. They're ahead of every lien on that property. They're ahead of the first mortgage, second mortgage, third mortgage, whatever. Right after taxes, those homeowners associations fall right in there, right ahead of all liens on that property. Now they knock on my door and they want their $72. I better pay attention. So that's how these homeowners associations work. Now this is only for associations that were formed after 1992.
So if the HOA was formed after 1992,
Yeah, if it was formed after 1992, this comes into play for them. Also, these associations have to register with the Real Estate Commission every year, or they cannot put a lien on the properties for non-payment.
Where is it in the new book?
but a lot of them don't know that.
Where's what in the new book?
The lien for assessment.
It should be on page 5-79.
Yeah,
Lien
later
for
in the book it
assessment.
gets kind of screwy.
Yeah,
The blue book.
yeah. Like I say, that's the brand new book. Anyway, Let's go to page 6-1. 6-1. 6-1, guys. And talking about Conway Bogue. This book could have started with Conway Bogue. I'll tell you what, why don't we take a 5-minute break? Okay, again, we're talking about Conway Bogue. Okay, let's get with it.
I don't mind getting up for you though.
I guess I did, right or not.
That's what we're doing over here.
Okay. Okay, again, page 6-1, second paragraph. Let's read this, guys. This is very important. We understand every aspect of Conway Bogue. In 1957, the lawyers sued to try to make it where you had to be an attorney to sell real estate. That's kind of like the opening of what we're looking at here. So let's read this second paragraph here. 6-1. Is that good for you too, Peter, in that book?
Yeah, good on point.
In the case of Conway Bogue Realty Investment Company versus the Denver Bar Association, the Colorado Supreme Court addressed whether real estate brokers could be, what's that mean? Stopped, enjoined, stopped from preparing certain legal documents relating to and affecting real estate and the title thereto, such as receipts and options for purchase, contracts of sale, deeds, deeds of trust, and leases, and from giving advice to the parties regarding the legal effect of the documents. In rendering its decision, the Colorado Supreme Court said, the first question to be determined is, does the preparation of receipts and options, all of these things, coupled with the giving an explanation or advice as to the legal effect thereof, constitute the practice of law? This question we answer in the affirmative. Yes, it does constitute the practice of law. The remaining and most difficult question to be determined is, should the defendants as licensed real estate brokers, none of whom are licensed attorneys, be stopped, enjoined from preparing in the regular course of their business the instruments enumerated above at the request of their customers and only in connection with transactions involving sales of real estate, loans on real estate, or the leasing of real estate, which transactions are being handled by them? This answer we answer in the negative. We should not stop them, is what they're saying. And the reason is the testimony shows that there is no effort to refute the same, that there are 3 counties in Colorado that have no lawyers. And what are those counties called? They're called Utopia.
Old history.
Utopia, write that down. Now we're looking back to 1957, 10 of each in which there's only 1 lawyer. 7 each which there's only 2 lawyers. That many persons in various areas of the state reside at great distances from any lawyer's office. The testimony shows without contradiction that the practice is sought to be enjoined, stopped, right, or of at least 50 years uninterrupted duration. That a vast majority of the people of the state who buy, sell, encumber, and lease real estate have chosen real estate brokers rather than lawyers to perform the acts being herein complained of. Though not controlling, we must make note of the fact that the record is devoid of evidence of any instance in which the public or any member thereof, layman or lawyer, has suffered injury by reason of the act of any of the defendants sought to be enjoined. Likewise, though not controlling, we take judicial notice of the fact that the legislature of the state, composed of 100 members from all walks of life and every section of the state, usually called upon by their constituents to adopt legislation designed to eliminate evils and protect the public against practices contrary to the public welfare, has never taken any steps to prevent continuation of the alleged evil which we are now asked to enjoin. when we're practicing real estate, I guess we're committing an evil out there.
Not
Isn't that
just on the
strange?
law.
Yeah, that's, yeah, right. We feel that to grant the injunctive relief requested, thereby denying to the public the right to conduct real estate transactions in the manner in which they have been transacted for over half a century with apparent satisfaction, and requiring all such transactions to be conducted through lawyers would not be in the public interest. The advantages, if any, to be derived by such limitations are outweighed by the conveniences now enjoyed by the public in being permitted to choose whether their brokers or their lawyers shall do the acts or render the services which plaintiffs seek to enjoin. This is a summary of the decision of the practice of law by brokers. The following is an excellent summary of the case given by John E. Gorsuch, legal counsel for the Colorado Association of Realtors, quoted from the August 1957 issue of the Colorado Real Estate News. It should be kept in mind that the court states that the practices in question do amount to the practice of law. The court says that it will stop real estate brokers from doing these simple acts, however, under the circumstances indicated because of the court's expressed belief that the public's best interest will be served by continuing the present practice. The present practice, however, means the practice shown by the evidence. In other words, the broker's activity is limited to the following circumstances. His office must be connected with the transaction as broker. There must be no charge for preparing the documents other than the normal commission. Remember, I have an attorney help me with a deal that's particularly tough, and they send me a bill, I have to eat it. I can't pass it along. The documents must be prepared on commonly used printed standard and approved forms, and it's clear from the decision that the broker should not, under any circumstances, top of the next page, prepare any legal documents as a business, courtesy, or favor for any transaction with which he is not connected as the broker, either with or without pay. And we've talked about this. Your brother or sister calls you up and says, can you help us fill out this contract? Either for a fee or for a favor. Either way, no, you can't. You have to be part of the deal. And he should not prepare any documents which cannot be properly prepared on the standard approved printed form. He clearly should not draw wills, contracts, agreements and so forth, except the initial binder contract or other customary agreements to the type used to bind the transaction or sale. In addition, it would appear in the best interest of the public and also in conformity with the court's opinion for the broker to always recommend to the purchaser that the title be examined, inform the parties that each has a right to have the papers prepared by an attorney of their own choosing, advise the parties that each has a right to be represented at the closing by an attorney if they desire. In spite of the permission to prepare these documents, there will inevitably arise situations in which the legal complications are beyond the knowledge of the broker. In such instances, an attorney's assistance should always be sought. In conclusion, it could be said that the Supreme Court will allow the brokers to prepare these legal documents on standard and approved printed forms by filling in the blanks therein with information obtained from the usual sources in transactions in which they are connected as brokers, when they receive no compensation for these acts other than their ordinary commission. It is to the interest of every broker that these limitations be properly recognized and followed, so that the Supreme Court would not have a reason to change its opinion at a future date. The final words of Mr. Gorsuch's summary bear repeating. It is to the interest of every broker that these limitations be properly recognized and followed, so that the Supreme Court would not have a reason to change its opinion at a future date. With privileges granted, there must be no abuse. The same authority that granted it may take a privilege such as this away. A privilege respected may be retained. A careless regard is not sufficient. There must be a careful determination and application of what is authorized practice of law by a real estate broker. The court in its decision referred to the use of standard and approved forms but did not elaborate. Consequently, it was necessary to establish what is a standard and what is an approved form. Any form purchased from a stationery store or printer may or may not be a standard approved form. The printer is under no obligation to determine what is standard or what is approved. However, a real estate broker may have such an obligation, and of course we do have an obligation. Therefore, the brokers needed some guidance and support in their determination of what is a standard and approved form. In the years following the Conway-Bogue decision, the business of real estate practice grew rapidly. There appeared to be less and less standardization of legal forms. Each association of brokers, each locality, and even individual brokers used their own forms, oftentimes drafted with personal prejudice. What are those called? What's that verbiage called? We talked about it yesterday.
What?
That word?
Protection.
Yeah, exculpatory. Remember that exculpatory language?
It's not
What's an exculpatory?
differentiated print?
Pardon me?
Such a differentiated.
No, that's
No. Exculpatory means hold harmless clauses. Hold harmless clauses. No matter how much I screw up, you can't sue me. Something like that. Exculpatory language is hold harmless clauses. Exculpatory is spelled just like it sounds. E-X-C-U-L-P-A-T-O-R-Y. Exculpatory. And the real estate industry. Oh, E-X-C-U-L. No. Hold harmless clauses. It means you can't have, like I say, no matter how much I screw up, you can't sue me. Something like that. You can't have language like that in there. Now, the real estate, you guys okay with that? Okay. And the real estate industry became concerned that its privilege to practice law within their limited sphere might be abrogated by the court. In 1970, the Colorado Association of Real Estate Boards passed a resolution requesting the Real Estate Commission to approve standard forms and to make their use compulsory. In response to this request, the Real Estate Commission held public hearings on the question. The consensus of opinion drawn from the hearing was almost unanimous. The industry wanted the Commission to use its authority to standardize forms throughout the state. As a result, the Commission in 1971 promulgated and adopted Rule F, which was submitted to the Attorney General. The Attorney General concluded that Rule F was a constitutional exercise of the Commission's rulemaking authority. Rule F covers forms for listing contracts, sales contracts, exchange contracts, disclosure forms, settlement sheets, extension agreements, and counter proposals. At the time of this writing, Rule F does not cover forms for business opportunity listings or sales contracts. Of course, they get that in, of course. Management agreements, they have that one in. There is not one for leases. There is one for deeds. There are actually none. There's none for deeds either. In these areas, the broker must use his or her best judgment. Now, the forms that do not fall under the purview of Rule F are, let's write these down, guys. You'll remember what they are. Contracts for deed. Remember, owner will carry contracts for deed. There's no approved forms for that. There's no approved forms for business opportunity. Business opportunity. Construction contracts. New homes with warranties. New homes with warranties. New homes with warranties. Leases. Deeds. So, whenever you're filling out these particular things, you should have an attorney's advice. Like I say, how do you pull up, say, a lease? You go on the internet and you pull up leases. There's a whole bunch of different ones on there that you can use. And there's no approved one. So you have to be careful. Everybody have all of those? Which ones you missing?
No standard.
You don't know which ones you're missing, you
Contracts
have
for
them, right?
deed, right, land contracts, business opportunities,
No.
construction, new home with warranty, leases and deeds.
Okay, one more time, Moses, let's do it.
Okay,
There's no
contracts for
funds
Contracts for
lease, right? Is
deed.
that what he's saying?
Yeah.
business opportunities,
Business opportunity,
We need that
Construction.
one from another.
construction contracts,
I got
new
that
home
part.
with
I
warranty.
didn't
new
get that
homes
part
with
of it.
warranties,
I just-
leases
leases,
It would-
and deeds.
I
and
just needed
deeds.
to know that.
Okay.
It was the ones we didn't have.
And what are these?
These are forms that are not approved by Rule F. Yeah, these are forms that are not a part of Rule F. Okay, now, let's flip over to page 6-7. So this Conway Vogue, guys, is kind of unique. We're about the only state to experience anything like this. Colorado is the only state that defines what we do as the legal practice of law. Because of that, we don't have to have an attorney look over our contracts. We don't have to have an attorney at our closings. And we don't want one. So we're fortunate in being able to conduct our business on a professional level. The trade-off to that, is, of course, we have to have 168 hours of pre-licensing training, and we have the toughest exam in the nation. And Texas has the most number of hours, and a state exam that's right on a par with us, really. Tough exam. Let's look on page 6-7 and look in the middle of the page, right in the middle of the page where it says, hence we conclude that where a real estate broker is dealing in real estate for his own account, the Real Estate Commission has jurisdiction over his acts and can suspend or revoke his license for proven violations of the licensing statute or of the Commission's rules. A broker can no more be allowed to violate the rules of the Real Estate Commission when purchasing property for his own account than he can when purchasing it for a client. Good information. Let's go to page 6-9 and look at the summary. The second to last paragraph on 6-9, right under summary. The change in the licensing law to bring Colorado under the majority New Jersey rule requires that a person must be licensed to receive compensation for the sale of a business or business opportunity where there is also a transfer of an interest in real estate or leasehold, no matter whether the interest or leasehold is negotiated or if the interest is insignificant in comparison to the rest of the transaction. Also, the transaction must not be separable so that one can avoid the licensing requirements and collect compensation on the basis of the sale of the business or business opportunity only. Good chapter, good little chapter there. And virtually everything we do revolves around this issue that happened nearly 60 years ago.
Wow.
Let's look at chapter 7, where it talks about interest in land and how we handle this. Bottom of page 7-1, where it says a unique concept of Anglo-American land law is that of estates. Estate types derived from the feudal system and are either freehold ownership estates or non-freehold, non-owned estates. Freehold estates were normal holdings under the feudal system and are fee simple absolute, defeasible or defeatable, or fee tail and the life estate. And no freehold estates appear to have begun primarily as a moneylender's device, begun primarily as a moneylender's device, and did not have the dignity of feudal stature. Non-freehold estates are leases, estates for years, estates from period to period, estates at will, and estates at sufferance. We'll talk about those. An estate is the type of ownership in land and determines the duration of an individual's right of possession and right of use. For example, if a fee simple owner leases property to a tenant for 10 years, both have interest in the property. The tenant's estate is called an estate for years and entitles the tenant to assert the right of exclusive possession against anyone, including the owner. The tenant must not abuse the property and has the limited right of use. The owner retains the right to possession at the end of the lease term, the present right to future possession. The interest of the owner is known as a reversion or a reversionary interest. What is the first right you get when you buy a property? You have right of possession. Without that right of possession, that property is worthless. But when you lease a property out, that's what you give up, your right of possession. But it's a reversionary right that's going to come back after that lease ends. Then we have the four major government limitations on land. We have a fee simple ownership interest, which is the highest form of ownership interest we can have, but it's never absolute. It has government limitations. Let's look at fee simple absolute, just a couple paragraphs above that, where it says, often called a fee or a fee simple, this is the most, remember this word, comprehensive bundle of ownership rights known in law. This bundle of rights include, and let's write these down, I don't like that list. These are the 5 bundles of rights, guys. The first one is always possession. Remember, possession is 9 points of the law. That means possession is 90% of all laws. Not only real property possession, but personal property also. What's that, Anima?
What are you talking about?
What am I talking about?
5 bundles of rights.
The bundle of rights.
Bundle of
The
rights.
bundle of rights.
Okay.
This is what gives our property its value. Back before we had deeds, what people would do is they take sticks and put them in a bundle and tie them up off that property, and they give it to the person and say, you own this property now where this bundle came from. It was the bundle of rights that they would give. And that's where this comes from. Now we've got the deed, we have title policies, we know exactly what we're getting now. And this bundle of rights includes, first of all, possession, number 1. Number 2, use or control for any legal purpose. Use or control for any legal purpose. Possession, use and control for any legal purpose. Quiet enjoyment, we have a right to quietly inhabit our property. We have a right to quietly inhabit our property. Exclusion, we can keep people out. Possession, use and control for any legal purpose. Quiet enjoyment. Exclusion, we can keep people out. And disposition, we can sell it. Disposition, we can sell it. One more time. Possession, use or control for any legal purpose. Quiet enjoyment. Exclusion, we can keep people out. And disposition, we can sell it or put a lien on it, encumber it. The 5 bundles of rights. Any questions on those? Can I say them again? I can do it real easy. Everybody got it?
Say it one more time.
Yeah, let's do it. Possession, use or control for any legal purpose. Quiet enjoyment. Exclusion, you can keep people out. And disposition are the 5 bundles of rights. Now, although fee simple, I'm reading again. And it says, a condominium is a fee simple estate created in airspace. You remember, condominium is an air lot. Although fee simple is the highest degree of land ownership recognized by law, it is never absolute ownership, such as owning this book, for example. An owner's fee simple title is always subject to governmental and private limitations that apply equally to all types of estates and land. And you have these 4 main government limitations: police power, eminent domain, taxation, and escheat. Police power. You think that the first time you see that, you think maybe Nazi Germany or something like that? Boulder. That's bad. And I said it on tape too. Thank you. You guys, you're bad influence on me.
That's the funny thing.
Okay. And police power. And again, police power has nothing to do with Boulder. Hello. That kind of police power. Anyway, Now, what we're talking about is like if there was a mess up here, and I say, well, why don't you come up here and police this area, bring it back into order? Police power is the most extensive of all government limitations because it covers what we can do with the property, which is zoning, how we can do it, which is building codes, and floodplains. Okay? One more time. It covers what we can do, which is zoning, how we can do it, which is building codes, and floodplains is what police power does. Then we have eminent domain. I guess I'll be doing with that police power. You can say it again real easy. Again, what we can do, which is zoning, how we can do it, which is building plans, and floodplains are the three things that it covers. Then we have eminent domain. Eminent domain. And guys, people will be asking you what eminent domain is. And what they think it is isn't what it is. Okay? Most people are totally wrong on what the eminent domain is. And it's this. Write this down. You've got to know this very, very well. Eminent domain is the government or public taking. The government or public taking, T-A-K-I-N-G, of private property for the public good. The government or public taking, T-A-K-I-N-G, of private property for the public good with just compensation. With just compensation. Again, the government or public taking of private property for the public good with just compensation.
Can you give a good example of that?
Now let's get the
Wait, we're not
definition.
done. I'm sorry.
By means of condemnation. The government or public taking of private property for the public good with just compensation by means of condemnation.
You know a little bit about eminent domain, don't you?
Of what?
Oh, yeah, we just got through talking about this. Told 5 others.
Yeah,
What's going on here?
just on the CAM class.
This is Lauren, by the way, guys.
How y'all doing? Good to meet you. How y'all doing? Good to meet you. Good. Hey, on CAM, just overheard something in the hall. About 35% of managing brokers, employing brokers, won't permit you to be a community association manager and be a broker for them. About 45 to 55, 65% will. So if you're trying to do both, make sure you talk to them first, right?
Really? So they encourage you to be both, huh?
About 55% encourage you.
Wow.
Depends on who you get.
That's pretty cool.
Well, because you create your own barrel to fish from.
Yeah, that's
Right.
true.
Sorry to interrupt.
Okay, thank you.
Can you repeat that last sentence?
And the others don't know.
Okay, let's do it again. Eminent domain, the government or public taking of private property for the public good with just compensation by means of condemnation. By means of condemnation. The government or public taking of private property for the public good with just compensation. That's the theory, is the just compensation. Nobody ever thinks they get enough from the government, of course. By means of condemnation. With just compensation by means of condemnation.
What's condemnation?
What is condemnation? I'm trying to take over your property, you're fighting me like a dog.
Okay.
I'm
That's
just
what I
going to
thought.
condemn it and take it. But we have a right to go to court. We have a right to go to court, and the court can decide on it.
I was just making sure I was thinking right.
Yeah. And it's a big part of our industry, and an example of it are all of these light rails that are going in. And they're condemning the backyard of these people's properties for that light rail to go through. That's the biggest part of eminent domain we have right now. Also T-Rex, the widening of the highways, are by having to buy people's property to make that happen.
In Chicago, where I used to live, they exhumed a bunch of bodies in a graveyard for O'Hare Airport. I don't know if that's
They exhumed a bunch of bodies for the
in a
airport.
graveyard to make
How
them
do they
the
get
airport.
away with doing that?
I don't know.
How do they get away with it? No.
Yeah.
I wonder.
They did to one of my shelves.
They did what now?
They went and they forced me to leave, and there was nothing I could do about it.
They forced you to sell your business and.
Well, I didn't own the property, but they forced me to move my business to. The option was either give me $20,000 or help me relocate to a different location.
Nice.
Not really.
Really?
I lost a lot of money on that deal. Because if you go to a new location, it takes years to build your customers back, and 20,000 is nothing in this world.
Yeah, anymore. Yeah.
And there's nothing you can do about it.
Okay, guys, let's go ahead and break. Okay, guys, let's keep continuing here. Bottom of page 7-2. Talking about the 4 government limitations. Remember PETE, police power, eminent domain, taxation, and escheat. Could each one of you explain what all 4 of those are? Y'all know what taxation is, but the other 3. Can you talk intelligently to people about it? And you don't have to put a name on it. You can just say, yeah, there's government limitations on our properties that tell you what we can do, which is called zoning, how we can do it, which is building codes. And a huge issue now is floodplains, especially since in 2013 we had all those floods up north in Longmont and Loveland, and those areas up there did not have flood insurance because nobody knew it was a floodplain. It's a 100-year floodplain, and 100 years ago there was nothing up there. People didn't know that was a floodplain, and so all these people lost their houses, didn't have flood insurance. They lost their houses. And it's funny, the media didn't pick up on that as hard as I thought they would. But I get people calling me and saying, yeah, I lost everything. I lost my house, everything.
Yeah, I lost my job up there because the place flooded out.
You lost your job?
In 2013, they had to lay off like a lot of people.
Yeah, the comment was, we didn't hear on the tape, up in Louisville, she lost her job because the business flooded and everything, yeah. Yeah. So all these things come into play, guys. These other entities around there that are supposed to be protecting us, they can't protect us from something that nobody knows about. And that's what this flood thing was. I was reading where, we used to have floods in Denver about every 2 years, every 3 or 4 years, because we didn't have Cherry Creek Reservoir or Chatfield. And terrible, terrible floods. I remember one year it wiped out Qual Paint. KW Qual Paint, you guys all know Qual Paint, at least you should. They're a local Denver company. And so they had a going out of business paint sale. And it made them. It made them. They made so much money on the going out of business sale that they're still in business 50 years later, So again, you never know how things happen. Sometimes blessings come in different looking packages. So, now how about deed restrictions? What are some other words for deed restrictions? CIC, because what's a deed restriction? It's a homeowners association document, isn't it? Mm-hmm. And what are these other deed restrictions? Deed restrictions, CIC documents, what's that stand for? Common interest community. Good. Common interest community. Common interest community. Why is it called a common interest community? Because you've got things around it that are a common interest to everybody in there. Remember, condominiums, the common interest is the actual exterior of the building. You don't own your walls. You don't own the clubhouse. You don't own the tennis courts or any of the land. But everybody owns it as tenants in common with an undivided interest. Well, that's definitely a common interest community because of all those things that are of common interest to everybody in there. But townhomes can also have common interest communities. If there's any part in there that's owned by everybody in the subdivision, then that's a common interest community. CC&Rs. What the heck's a CC&R? Stands for covenants, conditions, and restrictions. CC&Rs. Covenants, conditions, and restrictions. Same thing as a CIC document. Same thing as a deed restriction. Governing documents, not government documents, governing documents. Same thing, homeowners association documents. Bylaws of the association, same thing. Now, just for confusion's sake, or try to make it clarity, usually comes out confusion when we talk about this. All of these are different. They have different purposes. But as real estate brokers, we don't need to know them. We don't need to know them that well. We can lump them underneath put them all in the same bag if we want to. All of these are the same thing. CIC documents, CC&Rs, governing documents, deed restrictions, all of these things are the same thing to a real estate broker. If you become a community association manager, then you'll find out what the differences are. But you don't have to go that deep into it as a real estate broker. As long as you remember what they are. That means that there is a homeowners association. It means there are homeowners associations, conditions, covenants, conditions, and restrictions on that property.
So Jim, are you saying that not all deed restrictions, you can have a deed restriction without being in an HOA, correct?
You can have a deed restriction without being in an HOA. No,
You can?
no.
Okay,
No, a deed restriction is that. It's a private restriction.
okay,
And the only thing that enforces a private restriction would be the homeowners association themselves.
okay.
And there's some associations, guys, that are $2,500 a month to belong to them. Some of them are very expensive, and people like them. Some people like all that security, whatever you want to call it. And personally, I don't. I want as much freedom as I can get. But a lot of people love that. They look for that. So, yeah, they like it being heavily managed. They like the security guard romping around, things like that. That's knock yourself out. Well, some of these, and of course, remember, every homeowners association is non-profit. They can't make a profit. People say, I hate my association. Well, you are the association. It belongs to the owners in there. Who sets up the association?
The homeowners.
The developer, actually. The developer sets it up before he even starts building. And then once 51% is sold, he turns it over to the homeowners association. And that's who the homeowners association is. It's the people who live there. You're upset with your association? Get involved. Okay, let's go on page 7-3. We're not going to spend a whole lot of time on this in this part of the course because we covered so heavy in the law and practice part, in the national part. But I'm going to run through it real quickly, just as a preview of those who haven't had it and a review of those who have. I sell you this property or I give you this property. And on the condition, it's a defeasible estate. Defeasible is Latin for defeatable. Defeasible. Qualified. It means that you can lose this property if you do something you're not supposed to do. It's a defeatable estate. And the question on the state exam says, a qualified fee simple estate may be, and the answer is, reclaimed in the grantor's name if you do something you shouldn't do. I give you this house, or I sell you this house on the condition you never ever convert it into a commercial property. And you find out that it's got more value as a dentist's office. It's got mixed use zoning on it. So you change it to a dentist's office, I can come in and take that property back if I want to. You did something you weren't supposed to do. It was a defeasible estate, a defeatable estate, a qualified estate. I give you this property on the condition, I say, you can have this house so long as you don't convert it into a commercial business. If you do, I'm going to take that property back. I use the words, you don't have to write all this down, guys. Just kind of try to absorb. You can write it down if you want to. But we talk about it so heavy in the national part. I give you this property on the condition you can keep it so long as you don't convert it to a commercial structure. I use the words so long as, while, or during. As long as means the same thing as so long as. I use the words as long as, so long as, and it makes it conditional upon you keeping that property. You can't do it. So long as, while, or during. And I describe something happening to the property. You converted it into a commercial. That is known as a fee simple, defeasible, determinable estate. Fee simple, defeasible, determinable estate. I have another property that I sold these other people, and let's say it's sitting on a lake, and right outside between the lake and the house is a nice little beach out there, and I say, okay, you can keep this house, but don't you ever have a wild party out there with marijuana and booze, and if you do, I'm going to take it back. I did not use the word so long as, while, or during, and I described something happening on the property instead of to the property. That's a fee simple, defeasible, condition subsequent. Condition subsequent. Some other people, using Indian Tree as an example, gives like to Arvada Indian Tree Golf Course. And they gave it to the city of Arvada on the condition that it always stay a golf course. Always, always, always. If Arvada ever changes Indian Tree into anything but a golf course, that estate will take it back. That's a fee simple, defeasible condition precedent. I know. Serious brain damage, guys. Serious brain damage. You don't need to know this that well. Don't need to know this that well at all. What you need to know is what I told you before. Excuse me. A conditional fee simple estate may be, and what's the answer? Reclaimed in the grantor's name. Reclaimed in the grantor's name. That's the one you will have on a state exam, guys. They might have another one about that stuff. And if they do and you miss it, you're still going to pass the state exam. Okay? So don't spend 2 hours trying to get this down. You don't run into it that often. You do run into it out there occasionally. When we were up on 72nd and Federal, when the school was up there, the property was on 35 acres. It was owned by these people who received their property by inheritance from their dad. And there were 2 daughters and a son, and he gave it to them on the condition they never got married. And if they ever got married, the money then the property went to the Catholic Church. Another condition, they can never sell it. And if they sold it, the money went to the Catholic Church. This is about the only one I've ever run into, and it hit me right between the eyes. I was right in the middle of it, running
said
from
they
these
were
people.
able to get the money, right?
What happened is that the city of Westminster, I was talking to the planning guy, and he and I got to we got to know each other pretty well. He said, "I'll tell you what happened." He said, we told them to get an appraisal. We got an appraisal. Our appraisal came in at like 7.2 million. Theirs came in at 7.7 million. And we said, we're not even going to argue with you. We'll give you 7.7, and we'll talk to the Catholic Church, the powers that be, see what we can do. Even at that, these people fought them like crazy. They did end up doing it. They ended up buying it. And after they did, what I looked in the paper one day, and this few months later, and I see where Regis got a grant from somebody or got some money coming in for $5.2 million, something like that. And I thought, I wonder if that was from. It could have well been. I don't know. So you do see these occasionally out there. Very rare, but you do see them.
So what happens if the city or state forces them to get rid of the property? They still have to give the money to the church?
Okay, what if that didn't happen? The question was, what if the Catholic Church said, no way, we want all the money.
Sell it for a buck.
There you go, sell it for a buck. That's good, I like that, yeah.
But what I think William's question, what if it was eminent domain? At the city of Westminster,
This was eminent
enforced it,
domain. This is eminent domain, guys. That's exactly what it is. Let's back up. Thank you, Norm. Let's do it. What is eminent domain? I'll start you out. It's the government or public taking of private property for the public good with just compensation by means of condemnation. And how well should you know that? Like the back of your hand, because people will be asking you about it. And most people have no clue what eminent domain is. You guys do. Just that one 30-second statement says everything pretty much that you need to know about it. Again, the government or public taking of private property for the public good with just compensation by means of condemnation. Those long explanations, guys, break it up into pieces like I just did. The government or public taking of private property for the public good with just compensation by means of condemnation. That way it didn't seem like this big overwhelming statement. Hopefully that helps. Let's keep going here, guys. Let's talk about down here in the middle of the page talks about fee tail. Fee tail doesn't exist anymore. It used to be, I'll give you this property and keep it as long as your heirs keep producing heirs. If that ever stops, the property comes back to my estate. Whatever. If you ever see a question where fee tail is one of the answers, that's never the answer. Never the answer. Write that down. You're going to see them on the state exam. They throw that fee tail in 3 or 4 times on the state exam, guys. Don't you ever check that as one of the answers. Then we have life estates. Real quickly, we're going to cover this again in the national much, much better. We have 3 different types of conventional life estates. What happens is that this rich family, let's say that the grandfather or patriarch gives a property to his niece. Maybe it's a cottage for her lifetime. And when her niece dies, the property comes back to the estate. That's called a reversionary life estate. It reverts back to the estate upon the death of that person. That niece has a life estate. That niece has a reversionary life estate. It's going to revert back to that estate upon her death. Let's say that godfather or grandfather, whatever, instead of doing it that way, gave it to his niece, and upon her death, it goes to her daughter. Her daughter has what's called a remainder life estate. A remainder life estate. The first one, reversionary. If she dies, it goes back to the estate. The other one, if she dies, it goes to her daughter. That again is a what? It's a remainder life estate. I have a sick brother, let's say, and I ask this nurse, come in and take care of my brother. And you can live at the house, and what I will give you is a life estate based on my brother's life. As long as he's alive, you can live in that house. So you have a life estate based on someone else's life. That's known as a life estate per autre vie. Per autre vie. A-U-T-R-E-V-I-E. Autre vie. And we're going to talk about this again in much greater detail in the national portion. Like I said, this is a review for some of you, a good preview for the rest of you. 3 conventional life estates. Reversionary, remainder, per autre vie. Now, we also have 3 legal life estates. Bottom of that page 7-3, we have dower. That's when the wife survives the husband. She dies before the husband dies. And then on the top of the next page you have curtsy. Curtsy, that's when the husband dies before the wife dies. No, I'm sorry. When the wife dies before the husband dies. Just see if you're paying attention. You were. I like it. Okay. And again, so dower is when the wife. Okay, let's back up. When dower is the rights of the wife when the husband dies. Curtsy is the rights of the wife when the husband dies first. Colorado does not recognize either dower or curtsy. Other states do. Other states do. You'll still see a question about it on the state exam, though.
This is the Colorado Real Estate.
Pardon me?
Something in our Colorado Real Estate Manual.
Oh yeah, and it mentions it because these are different types of estates out there that you may run into.
Just not Colorado.
And not in Colorado, but you could see in other states. So all this comes into play. Now, there's a third life estate, and it's called homestead. And this is where if I declare bankruptcy or I have a home foreclosed, what happens is that if if I have a ton of equity in the property, they'll pay off the taxes. By they, I mean the lender who's ever foreclosing on me. They'll pay off the taxes. They'll pay off all the liens. And then if there's any equity left over, I get all that equity up to $60,000, $90,000 if I'm disabled. Okay? Go to page 7-6, bottom of the page. What I just said. Bottom of page 7-6, top of page 7-7. If you want to read that paragraph on the bottom of page 7-6, just read those first few paragraphs up there. Explains it pretty well what this is. Very obscure law. Very few people know about it. You don't have to apply for it. It happens automatically on your property. Now, We're going to talk about this in greater detail when we go over it. Homestead exemption is allowed in Colorado. It's one of the 3 legal life estates. Dower, when who survives? The wife, curtsy, the husband, and then homestead are the 3 legal life estates. And as we talk about in the general portion, it's very rare for the man to survive the wife. It just doesn't happen that often. I think it's you women kill us off. I think it's what it boils. I think that's the plan.
agree.
That's the plan. You know, I don't blame you. I don't blame you. But
Sure you deserve it.
that's right. We deserve it. I tell you. Yeah, I kid around
Third
about.
wife.
I kid around about that. You know. Yeah, I'm a single guy,
Probably.
and they have studies out there where they say that married people live longer than single people do. Well, they've done other studies where that's not necessarily true. It just seems longer. Let's talk about this dower part here. Dower.
That was a good one.
Dower, where again, this is the rights of the wife. Remember back in the good old days when the wife used to have to bring something of value into the marriage? Do you know why she had to bring something of value in the marriage? Because she couldn't go on title. Remember we talked about that? A woman wasn't allowed to go on title. Is that insane? That didn't turn around till like the 1920s. And so what happens is that, so you want to marry my son? Well, he's got this estate and on and on and on, and you marry him, then all of a sudden you won't have that estate and you're not even on title. You know, so she would have to bring a dowry into the marriage to make it work. I was reading an article where in India they're having a heck of a time with that because all these guys are marrying these women, getting their dowry and then disappearing. Having a heck of a time with it. So it's kind of wild. Where the converse of that in China, you know, they've had a one-child policy for many, many years trying to get their population down and everything. And what happened, a lot of times if you had a baby girl born to you, they take it out and just kill it because they can only have one kid. And because of that, there's a real shortage of women out there. And some of those provinces in China, the man is bringing a dowry in just so he could kind of buy his wife, kind of thing. Yeah, but it's normal. Anyway, so just kind of different, the different way these things work. You can see they cross international boundaries, everything. Let's go to page 7-4, middle of the third paragraph, non-freehold estates. There's 2 types of estates. Freehold and non-freehold, yes. Freehold and leasehold. Leasehold, right? Leasehold. Now don't think about this. Don't make this complicated. If there's a lease on the property, what kind of estate is it?
Leasehold.
Very good. Leasehold estate. If it's not a leasehold, it's a freehold estate. We talked about the freehold estates. Now let's talk about the non-freehold estates. The first one is an estate for years. Everybody see that? Now this estate for years is interesting. That's what a lease is. And a lease doesn't have to be for years. It could be for a few days, could be for a week, could be for 99 years. But if there's a lease on it of any kind, it's called an estate for years. It has a definite beginning date, a definite ending date. A lease has a definite beginning date and a definite ending date. I have a 1-year lease on your property. My lease is almost up. How much notice do I have to give you that I'm moving out? It just ends. It's just 1 year. It has a definite beginning date, definite ending date. I don't have to give notice. I just have to be out by that ending date.
Notice is only if you break the contract.
Unless you renew it, right?
Unless I renew it. Now there's several ways I can renew it. What if I go and bring a check to the landlord on the first day of the 13th month? That renews that 1-year contract for another year if he accepts that check.
Oh.
Now, but how do let's go back to how it works in real life. We have a 6-month lease.
I was going to answer your question before you did.
Oh, okay. We have a 6-month lease, A 6-month lease, which is an estate for years, has a definite beginning, definite ending time. And then it rolls over into a month to month. A month to month doesn't have a definite ending date. You just renew it at the end of the month, or beginning of the next month, I should say. And that is known as, again, an estate. Let's look at it here. This is called, where am I here? Okay, 7.7-4, we have an estate for years, and then we have an estate from period to period, or periodic tenancy. It doesn't have a definite ending date. It just rolls over, Now, on a month-to-month estate, you have to give a 10-day notice of eviction. Now, how are most month-to-month written? You have to give a 30-day notice. And that's fine. That's fine. You have to have at least 10 days. So 30 days works fine. Okay? And again, an estate for years, definite beginning, definite ending period. Then it rolls over into an estate from period to period, or periodic estate. And then we have something called an estate at will. This is where I call up my buddy. And I say, John, I heard your wife kicked you out again. Why don't you come stay in my basement till you get back on your feet? Well, I'm not going to have a lease with John, probably. And what's he doing? He's staying in my basement. No lease, no nothing. That's called an estate at will. An estate at will.
Like a verbal contract?
A what now?
Like a verbal contract?
Yeah, it's a verbal contract. I'm not going to have I might have a lease with John, but probably not. And this is called, again, an estate at will. Several things can end an estate at will. Death of the parties, either party, destruction of the property, sale of the property, unless other arrangements are made, and also a 3-day notice of eviction. That's on the state exam. An estate at will, 3-day notice of eviction for an estate at will. Three-day notice of eviction on an estate at will. Smile when you see it on the exam. You're going to nail it, okay? And then we have an estate at sufferance, which isn't an estate at all. That's really a misnomer. This is where maybe you rent your property to these people and it goes into foreclosure. And after the foreclosure, the new owners go into the property. They go into the property and there's the renter still in there. Those renters have what? An estate at sufferance? Not really. They have a lease at sufferance, if anything, a rental in sufferance, a holdover tenant, a tenant in sufferance. It's not an estate. They don't own anything down there, and they're against the wishes of the owner, aren't they?
So is that
And what's going to happen? Yeah.
Is that an unlawful detainer?
Is that unlawful retainer?
Detainer?
Detainer? Unlawful detain on whose part? On the bank or on the people in there?
On the people in there?
Would it be is it unlawful detainer? You could call it that. You could call it that, but I wouldn't go that far, because what's happened, this bank goes in there and looks at these people, and usually what they do is they say, you know what, you're keeping this place up very nicely. Tell you what we'll do. We'll let you stay here for 3, 4, 5 months for free, and we'll even help you move out. We'll give you a couple $1,000 to help you move out. Just because you don't want that home sitting there vacant. Remember, now the bank owns it. Okay, and you'll see a lot of this happen. They call that cash for keys, if you see that type of statement. Okay? So there again, that's a tenant at sufferance. Tenant at sufferance. Any questions about that? So that's what all leases fall underneath those 3 categories. And so now this is estate for years. Let's spend another few minutes on this. I have a 1-year lease on this property. Halfway through my lease, the landlord dies. What happens to my lease? Continues. Exactly. Right, so the landlord dies. What happens if I die halfway through the lease? That landlord can actually go after my estate to get that. They don't. They typically don't. Especially in this market. You kidding? They can rent it for more than what they rented it to me for, right?
Right.
So again, but yeah, they can. Both parties can act even in the event of death
But
of
they'll
the
keep
parties.
the security deposit or whatever, right?
and the security deposit has something to do with it also. See, that's why when you have an estate at sufferance or a tenancy at sufferance where they're in there beyond the sale, these, remember, possession is 9 points of the law. 90% of the law has to deal with possession. Well, these people are in possession, aren't they? If they're a holdover tenant after the deal's over with and everything else. What about their deposit?
You cannot
Whatever
deposit
happened to
in lieu
that?
of rent.
What's that?
You cannot keep the deposit in lieu of rent. You cannot.
Well, the point is, these people have rights. They have things that have to be settled here. And so the bank, most banks are saying, we're just better off letting them stay in the house. They're keeping it up, and let's leave well enough alone for right now. Because I'll tell you what happens, guys. More times than not, and I've heard I hate these stories, where you do a flip and you spend 30, 40, who knows how much to get this flip done. And you put it out there, and you're going to keep it. You're not going to sell it. You're going to rent it out. And you put a for rent sign out there. You know what that tells everybody who goes by? That home is vacant. We get more and more homes where people jump in there and pull all the copper out of the property. And it takes 15 minutes to do that.
Personal experience?
Yeah, not personal experience, no. Good grief, no.
So would you recommend don't put a sign?
No, not in this market. In this market, you put a sign out and you're leased at the end of the week.
And same thing with if that home's in foreclosure, okay? And you lease it with a broker, people walk by, they look in the window, they don't see any furniture in there. Tonight at 2 a.m, we're gonna go take all the copper out of that house.
Well, that's why
Can
you
you
just
put
get
up one of
rescue
those
dogs and you
little-
put them on your property.
Rescue, that'd be wonderful too. Then the dog bites somebody and you end up getting sued by them. Isn't that wonderful? Yeah.
Little ADT.
Well, if they're
What's
in the
that?
house,
Those little.
then the dog has every right
ADTs
to
or
bite
whatever.
them.
Guys, security is a big part of our industry, and boy, it's becoming more and more a part of our industry. There's always new ways of being a crook out there. Wow. So anyway, that's what we're talking about here. Even though they're holdover tenants, they still have rights. Possession is 9 points of the law. Now, let's talk about the 3 ways we can take title in Colorado. Bottom of page 7-4, joint tenancy. Let's read this. All co-owners, before we do that, concurrent interest, right above it, concurrent interest. An estate and land may be owned by one person in severalty. That's how one person owns it. And it's confusing because it has the word several in it, but it also has the word severed in it. You're severed from any other ownership interest. Then you have joint tenancy. Let's read this. Well, let's back up just a little bit. First of all, corporations own property in severalty because the government considers a corporation an individual. So corporations own property in severalty also. If 2 corporations go in and buy a piece of property together, they could buy it as tenants in common. The 2 corporations can, but they'd be foolish to. They'd be better off forming a separate corporation and buying it underneath the auspice of severalty, just for tax purposes and things like that. But to say definitively a corporation always has to own property in severalty is not necessarily correct. Again, if 2 companies go in there, they can buy it as tenants in common. Let's keep going. Let's look at never joint tenancy. Let's read about joint tenancy, bottom page 7-4. All co-owners are equally entitled to the use, enjoyment, control, and possession of the land or its equivalent in terms of profits. The best known characteristic of joint tenancy is the right of survivorship. Upon the death of one joint tenant, the decedent's rights pass immediately to the surviving tenants. Death of a joint tenant does not affect title, as the title is vested equally in all joint tenants rather than individually. The 4 of us buy this property as joint tenants. All 4 of us have equal ownership interest. There are 4 unities of joint tenancy. The unities of joint tenancy are P-I-T-T. Remember we had P-E-T-E, just all these other P's. Remember, police power, eminent domain taxation, and escheat are the government limitations. We also have the 4 unities of joint tenancy. All 4 of us have a right to possess the property. Well, we can all live there. Each one of us has a right to live there. Right of possession. We all have the same amount of interest. We all own 25% interest. We all took title at the same time with the same title document. Possession, interest, time, and title. Yeah.
Is that where you see like a vacation house? It's like some big extravagant vacation house, and like a few people have like a certain section of the year where they can go use it.
A big vacation house where certain people have certain times of the year where you can go use it. Actually, what is that? That's not necessarily this. Timeshares. That's what we're doing with timeshares now, guys. Up in the mountains, you're seeing these people. You have 3-month timeshares. 4 people own this place, with each one 3 months out of the year. Now, can I have it set up like this for that situation? The 4 of us are going to buy it, and we're going to split it up between us for that time of the year. Sure, we can. Sure, we can.
But that's
Do you have a story for us? Something happened with you on that?
I've just seen like down in the Keys, I used to rent the house in the off season, and there was these houses that were like you could buy like be like $500,000 in, and you get this huge $7 million house or something. It was
Okay. See, and what you're talking about, that was pretty quiet. You probably didn't pick up on the microphone. But he said down in the Keys, he was doing this. And it was fairly popular because here's a $7 million house where I can buy it and use it 3 months out of the year for a fourth of that. Is essentially, and those are timeshare issues.
I don't want to speak for him, but I think what might have thrown him off is the word time. The usage of the word time isn't you get equally split time. The word time is used, you must take title at the same time.
Yes. Different kind of time. Okay, that's pretty good. Thanks, Norm. Possession, we all have a right to possession. We have the same amount of interest. We took title at the same time with the same title documents. Okay? Let's keep reading here. According to common law, joint tenancy must feature 4 unities: time, title, interest, and possession. Just the opposite of what I just told you. That's okay, though. Joint tenants must acquire title at the same time, be named in the same deed, hold exactly equal interests, and be entitled to equal rights of possession. A conveyance from an owner in severalty to herself and her spouse could not have created a joint tenancy under common law because the entities of time and title were missing. And that's more than what you really need to know. However, under Colorado law, a deed would create a joint tenancy. But that's more than what you need to know. I just wrote that so you wouldn't read it and get confused. For all intents and purposes, the 4 unities have to be there: possession, interest, time, and title. Now, married couples usually buy property as joint tenants with right of survivorship. Let's go to page 7-6 and look at that 4th paragraph where it talks about tenancy in common. Let's read this. Tenancy in common is an estate and land held by 2 or more persons with only the unity of possession. Unlike joint tenancy, tenants in common may take title at different times and may receive their interest through different deeds, but each is entitled to the undivided possession of the property according to their proportionate share and subject to the rights of possession of the other tenants. Upon the death of a tenant in common, there is no right of survivorship. The decedent's interest passes according to his or her will or the state laws of descent and distribution. How would that kick in? State's laws of descent and distribution. Die without a will.
Right.
Very good. You die without a will, intestate, right? And you do have heirs. State will be settled through that state's laws of descent and distribution. The court will appoint an administrator to carry out its provisions, and that process is called probate. Now, so the 4 of us buy this other property as tenants in common. So we own 2 properties. One is joint tenants, one is tenants in common. The tenants in common property, let's say I die, okay? Where does my estate go? My share. Tenants in common, where's my share go? Where?
Your descendants. if
To
you
my
have them.
descendants, to my will. Yeah, to my descendants, whoever I want to go to in my will. They don't get any of my share. I can give them a cut if I want to, but let's say in this case I give it to my family, it goes to my estate. Joint tenancy, on the other hand, if I were to die, before I hit the ground, they own my share. We have the 4 unities of joint tenancy. Okay? Now, we have the 4 differences between joint tenancy and tenancy in common. I'll start with the common one. What right is common? Whether you have joint tenancy or tenancy in common, and that's right of possession. Right of possession. Right of possession. No matter how we own it, we all have a right to live in that property. Right of possession. That's the one that's common. Whether we both own this property. The 4 of us own it. One is joint tenants, one is tenants in common, right? Either one of those, we all have a right to live in it. Right of possession. Now, some other differences. Joint tenancy cannot be willed. Joint tenancy cannot be willed. Because before I hit the ground, you guys own my share, right? I can't put it in my will because it doesn't exist anymore. As soon as I die, my share's gone. And these 3 guys own it. They all own 33 1/3. One of them dies, the 2 remainder have 50-50, and finally the last survivor gets the property in severalty. Okay? It cannot be willed. Joint tenancy cannot be willed. Joint tenancy cannot be probated. You don't have to go through a probate action on joint tenancy because the property doesn't exist anymore. In my name. Joint tenancy must. Do you have a question?
Yeah, what happens when the last person dies?
What happens when the last person dies? Then they goes to their estate.
Then, okay.
Yeah, to their estate. Unless they die intestate, then of course what happens then? It goes through that state's laws of escheat. Right, escheat. That's if you die intestate without a will. With a will, goes through that state's laws of descent and distribution by means of probate. You think you're going to look good when you're talking to your people about this stuff, guys? Pretty good stuff. Okay, now, let's keep going here. So we have tenancy in common, joint tenancy, and severalty. Let's go down to concurrent conveyance, middle of page 7-8. It says, ownership of a home by a husband and wife is usually declared by the deed to be in joint tenancy or as tenants in common. It better. What if in the contract or in the deed it doesn't say how these people own the property? Our default provision would be tenants in common. Not joint tenancy, tenants in common would be our, because joint tenancy happens automatically. If we leave it blank, the people will automatically own it as tenants in common. Joint tenancy must be in writing. Okay, now, the automatic and immediate right of survivorship that accompanies joint tenancy eliminates some legal complications of probate in the event of the death of one of the parties. However, inheritance taxes are assessable and evidence of the death must be recorded. Joint tenancy ensures the survivor a fair share of the marital property, and the property does pass free of all claims as unsecured creditors. You don't need to know all that about this. The main thing about joint tenancy is that you have your automatic right of survivorship. That's why most married couples buy property as joint tenants. Disadvantages of joint tenancy may arise if marital difficulties occur, or if one of the parties has obligations or responsibilities like children resulting from a previous marriage. The financial and tax situation of the parties may also favor tenancy in common. Although it is, now pay attention to this, guaranteed question, here we go. Although it is helpful and proper to explain the meanings of joint tenancy or tenancy in common, a broker must never advise a client what type of conveyance is best. To do so exceeds the role of the broker and constitutes the unauthorized practice of law. So we're filling out the contract, and we say, okay, how do you husband and wife want to take title? And they go, really? What do you mean? Well, you have a choice in Colorado. It can be joint tenancy or tenancy in common. And they're going to say, well, what do you recommend?
We're not allowed.
Very good. We're not allowed to recommend. We can explain the differences and have them choose. Guaranteed question, guys.
Is
You're going
that
to
the
see
one
it.
we leave blank and we can suggest that they take counsel?
What you want to do, the question, the statement was, we just leave it blank, put down TBD? Oh yeah, that's exactly what you'll do. And just fill it in later. And what if you space it? Believe me, that closing lady's going to call you up and ask you. It would default to tenancy in common. But usually that closing lady, the title people, are going to call you up and say, hey, how are these people taking title? Now in the state exam, they're going to say, if they ask about joint tenancy or tenancy in common, we recommend they go see an attorney. Okay? What do we do in real life? We explain the differences and have them choose, but we never, ever recommend. Our default provision, if we leave that blank, is tenants in common. What are the default provisions that we talked about? If you leave something blank in a contract, it would automatically default to, I leave the deed blank. What's it going to default to? General warranty deed. Very good. A general warranty deed. General warranty deed if I leave it blank. That's another default provision. What's another one? If I leave how I'm working with the people blank, it will default to transaction broker. So those are the three default provisions we can have in a contract. Yeah,
Jim,
again.
Can I ask you a question? What if someone wants to put a home in the name of a trust? Can they hold that in either tenants in common or joint tenancy?
Okay, let's spend just a few minutes on that because I can spend the next hour talking about a trust, okay? This is kind of a complicated question. The question was, what if you put in a trust? Can you have in a trust as joint tenants or tenancy in common? First of all, so I have my estate, and I'm a jillionaire, right? So I have all my money, all my estates, everything I own, underneath a corporate umbrella to protect my private assets. Then I put that corporation into a trust. What does that mean? It means that I don't own that property anymore. The trust owns the property, but I own the trust. Okay? So again, how is that property going to be settled in that trust? The exact same way. The exact same way. And we'll talk about trusts and corporations, things like that in another part of the course. So, anyway, good timing. Let's take about a 10-minute break. Okay, gang. Let's rock. Keep going. So there's three ways we can take title in Colorado. Severalty, joint tenancy, and tenancy in common. There are two other ways you can take title in other parts of the United States. One is called tenancy by the entirety, and there's 23 states that fall underneath that jurisdiction, and in those states, it essentially forces married couples to take property as joint tenants. Tenancy by the entirety. The other one is community property states, which are what most Western states are. I'm not going to spend a lot of time on either one of those because we hit them in the general portion, and there's nothing. There might be a reference question on the Colorado exam about the 5 different types, but nothing specific. On the general portion of the state exam, you will have specifics about that, especially community property states. Okay, this is just a preview now for those two. We're not going to go into a lot of detail on those because we're going to hit them in the national portion. So much heavier. Okay. Let's go to the bottom of page 7-10. 7-10. This last paragraph on 7-10, kind of a wild paragraph. Well, I want to read it to you so that you don't read it and come see me and say, what the heck does this mean? Okay, so let's read this. Last paragraph, page 7-10. A state's rights and interest in such areas shall pass by descent and distribution in the same manner and as a state's rights and interest in land, and may be held, enjoyed, possessed, alienated, conveyed, exchanged, transferred, assigned, demised, released, charged, mortgaged, or otherwise encumbered, devised, and bequeathed in the same manner, upon the same conditions, and for the same uses and purposes as the state's rights and interest in land, and shall be in all other respects dealt with and treated as the state's rights and interest in land. Is that the biggest bunch of garbage you ever read in your life? And all that is a bunch of course, legalese and ridiculous. You have 5 different sentences there that they all drug together. And the reason I read it again, do you need to know what all of those terms are? Yes, and you will know what they are. You will know what they are. But to just throw them at you like that is just overwhelming. You're going to be fine. You don't have to panic if you were to read that yourself. Let's go to page 7-11 and look at the second to last paragraph. Actually, the third to last paragraph on that page talks about common interest communities. Why would it be called a common interest community? We talked about it an hour ago. Because there's a common interest in the land or the tennis courts or whatever else is there, right? Like people will ask me, can we get rid of our homeowners association? Well, of course you can. The government could care less if you have a homeowner association or not. But if you've got common interest that has to be taken care of, how are you going to take care of that without an association overseeing it? But if you've got a homeowner association where there's no common interest anywhere, you can dissolve it. Yeah.
So, one of my houses, the house I used to own, when I first moved in there, they told me because it's after 10 years or 11 years, there was no longer no home association. Does that make sense?
Let's back up. The statement was they moved in there and there was a homeowner association, and after 10 years,
I think it was 10 years. Might have been 10.
Well, have you been paying dues in all that time?
No. When I bought the house, they told me there was no longer no association fees at all.
If there's no money, guys, there's no enforcement. If there's no money, there's no enforcement. If there's no enforcement, there's no rules. If there's no rules, there's no association.
But
is what it boils down to.
Some new developed property areas have some type of clause saying after 10 years there's no longer association fee?
The statement that after 10 years there's no association fee. Never. They will never have that clause because somebody has to keep up the common areas. Why was that association fee there to begin with? Because it was necessary.
Okay, so then why at the end there was none?
Why at the end there was none is because there never was any to begin with because there was no money. And without money there's no enforcement. With no enforcement there's no association. So you can have, I lived in a place, a while back where they had an association with no monthly dues. Well, you don't have an association then because you have to have the money to support it, and there isn't any money. Without money there's nobody around to actually go over there and make sure everything's being taken care of. So it didn't exist after day one, actually. And after 10 years, they just got rid of it. Just automatically disappeared. It's probably fine. It's just wrote it out in writing, It was never a legitimate association to begin with. Now, every time we see a PUD, a planned unit community, PUD, planned unit development, I said community, I misspoke. Planned unit development, a PUD, planned unit development. If it has a homeowners association, it's a PUD. It's a planned unit development. Now, we might have these small, like what Michael was just talking about. These associations might be so small, the one I lived in, that it's a de minimis PUD, which means a small, insignificant PUD that really doesn't even exist to an extent. I had a de minimis PUD that did exist. It was $6 a month. I told you guys that story. If I haven't, I'll tell it to you. But $6 a month. I paid for the sign out front and to pay for some kid to mow the lawn around it. $6 a month. That's a de minimis PUD. D-I-M. I-N-I-M-U-S. De minimis PUD. De minimis PUD. when you're out there talking to people and you're saying, okay, I'm going to show you this subdivision, and the last one we went to look at, their association fees were $350 a month. This other one is a de minimis PUD. Its association fees are $20 a month, $50 a month, something like that. And all of a sudden you use that term, especially when you're talking to developers, when you're talking to lenders, knowing the correct verbiage. Calling it not just a PUD, but a de minimis PUD, wow. Remember, everybody who talks to us as real estate brokers, whether they're the underwriter for a company, for a lender, whether they're an inspector, no matter who they are, whenever they call up a real estate broker, they usually start way down here as far as intelligence level goes. They'll say, well, if I go any higher than that, this real estate broker won't understand a thing I'm saying. It's not going to be that way with you guys. You will be able to understand them. You'll be able to talk above them when you're out there. And it's a delight to work with people who know what they're talking about and they know these terms in the industry. It makes everything flow so much easier. And you don't think your reputation goes out there that you know these things? You better believe it. That's how you become a professional, is knowing the terms. Okay, let's go to page 7-12. Third or fourth paragraph there where it talks about timeshare interests may be either fee simple, deeded, or non-deeded right to use. Okay, timeshares can be either leased or purchased. And timeshares come and go in popularity within our market. Some people love them, some people hate them. The one bad part about a timeshare is there's no aftermarket for it. In other words, you don't buy a timeshare as an investment. Okay, you buy it as strictly a use issue. And they're hard to sell. You know, there's companies out there that do nothing but sell timeshares. And again, you've got to make sure you know what you're getting into with a timeshare. They're not for everybody. I had a buddy of mine, he and his wife bought one here a few years back. And I asked him, I said, why the heck did you do that? Well, they're both appraisers, and they're extremely busy. And they said, we bought a 2-week timeshare, so we're forced to take a vacation every year, 2-week vacation every year. I went, wow, perfect reason to have one. Plus, you get discounts on hotels and airplane fares and everything else throughout the year. So there are some that you want to belong to. This could be a way, again, to force you to take a vacation. I should buy a couple. Get right down to it. I think I just thought about that. Shoot.
Do it
And
after
really,
the class, though.
what's that, after class? Okay, you're on. Let's look at the second to last paragraph on page 712. A co-op. This is where picture condominium, and you don't buy the individual units. This whole condominium building is owned by a corporation. We buy stock in the corporation equal to the value of that unit. And because we're buying stock instead of real property, we don't get a deed, we get a, look at the last line in that second last paragraph, proprietary lease. You will not have any questions about a co-op on the Colorado portion of the exam. None at all, but you will have them on the general portion, because there's only one co-op in the entire state of Colorado. It's between Glenwood and Aspen. And when we were doing the questions for the state exam, we all decided, no, it'd be stupid to have questions on co-ops when there's so much else we could talk about. Now, let's go to page 8 here, land descriptions. And this one we cover in the general portion in total detail. We're not going to go over this, but we are going to run through it. Now, those of you who have not had this yet, don't freak out, okay? You will get this. But those of you who have had it, who had this, where the acreage, timeshares, good read. The acreage, I am. I'm ready to go out and buy one, you bet. So we have, again, on this we have the square footage in an acre, sections, townships. Who's had all that? About half a dozen of you or so. Okay, for those of you who've had it, this is a review. What's that? Was that Charity?
I've technically had them, but I have missed them.
Well, good. See, now you're one of the ones going to benefit from this. You ready? Let's run through it. How many square feet are in an acre?
43,560.
And the 43,560, and the way you remember that is 3, 4, 5, 6, and then a 0 after it.
Jim,
Yes.
I think what helped me remember, because at first I was having a hard time, was when you put the 7,
The 7 and 11,
on
you
top.
bet.
I think
4
that really
plus
helped me a
3
lot.
is 7, 5 plus 6 is 11. Between those two, you should have no problem remembering how many square feet are in an acre. 43,560. A football field is about 45,000 square feet. So if you want to get a mental picture of an acre, picture a football field.
Oh, wow.
Now, how many acres in a section?
640.
640. How many sections in a township?
36.
36. What are the north-south boundaries of a township that run east and west?
Those are the tier lines.
The tier lines. Which are the east-west boundaries that go north and south? Range lines. Every township is measured in relationship to what north-south line?
Principal meridian.
Principal meridian. What east-west line?
Baseline.
Baseline, like Baseline Road coming out of Boulder. What are the school districts in a township?
16 and 36.
16 and 36. When we're measuring properties in terms of depth or height, they're based on a datum. Every fourth township has a line that stretches it out to exactly 6 miles. That's called a correction line. Correction line.
I gotta study that.
Now, those of you who've never heard this before, sounds like a ton. It really isn't. It really isn't. We take it section by section by section, and you will know it at least as well as these people who are just answering it. So, something to look forward to. Let's go to page 9-1. 9-1. Again, we cover this very heavy in the national portion, in the law and practice portion. Actually, we use both books to cover it. Deeds, transfer of property, deeds. That's how we transfer real property. How do we transfer personal property?
Bill of sale.
Bill of sale, good. Let's look underneath that number 4 there, okay? Descent. Title transfers by descent when a person dies without leaving a will. Intestate. Your property will what? Be decided by that state's laws of descent.
Distribution.
The guy had a wife, 2 kids, a brother, that's probably to the line of descent. Decide how it's going to be distributed. They'll appoint administrator to carry it out, and that process is called probate. Okay, let's do this. Let's go over to page 9-5. Top of the page. There are only 4 types of deeds. Top of the page there. All deeds, there are many types of deeds, but they fall under these 4 headings. We have a general warranty deed, a special warranty deed, a bargain and sale deed, and a quitclaim deed. Now that quitclaim deed has, I keep pronouncing that T because it's spelled with a T, not a CK. A lot of people say, remember I told you about these crooks, these investment groups, guys that I've been to? Not, you can call them crooks. I may miss, I'm not saying their names. You don't know who they are or anything. But for all intents and purposes, they're crooks because they don't know what they're talking about. And they say, you don't need to have a real estate broker. Just go on title with the people. Just have them give you a quick claim deed. Yeah, it's not a quick claim deed. I saw a Western last week. They gave a quick claim deed. So it must not mean anything. Well, yeah. You quit your claim on that property. It's with a T. You quit your claim on that property with a quit claim deed. Let's start first with bottom of page 9-3 and talk about a special warranty deed. They use that word warranty. What the heck's warranty mean? What do you think?
Protection.
Warranty, protection.
Against defects?
Yeah, well, it's a protection covenant, a promise, a guarantee, a warranty, all mean the same thing. A guarantee, a covenant, a warranty, all mean the same thing. And there's only 2 deeds that have warranties. The first one at the bottom of the page is a special warranty deed. Let's read this. Everybody there? 9-5, bottom of the page. The grantor of a special warranty deed warrants the proper title only against defects arising after the grantor acquired the property and not against title defects arising during that time. And again, what did I say that?
You said during, before that.
Arising before that time, I'm sorry. It's only for the time I've owned the property.
Grantor being the seller, right?
The grantor being the seller. Why don't we use this word seller? Why do we use grantor?
You
Because
don't
you
have
don't
to
have to
sell.
sell.
You might be giving it away. In that case, you're not the seller, are you? But whether you're giving it away or selling it, you're always the grantor. That makes sense. So, the grantor is only warranting it for the time I've owned it. That's a special warranty deed. This is the type of deed you get from a developer. How's the heat in here? It's okay? We're okay? All right. Let me know, guys. Like I say, I'm always hot up here, so you got to tell me. All right. So a special warranty deed is what you get from a developer primarily. When you're selling your property, you want to give a special warranty deed. It's still a warranty deed, and you're still giving them a warranty on that property. It only covers the time you owned it. It limits your liability issues. So you want to give a special warranty deed. Now, right above it we have general warranty deed, which is the strongest of all deeds. It's the most common of all deeds, and it has 5 promises. 5 promises. We have a covenant of season. Boy, you're going to see that word on the state exam, guys, and I've seen it spelled 8 different ways. They spell it with Z's, all kinds of stuff. Spell it any way you want to, as long as you can recognize it. Season means possession. Season is Latin for possession. Now, covenant of season, which means when I'm transferring to you, I have the right to transfer. When I'm transferring it to you, I have the right to transfer. Covenant of season. Covenant against encumbrances. What the heck's an encumbrance?
Yeah, that's true.
Anything
that
Limits your use
title
or
interest.
title or value.
I like it. Anything that limits an encumbrance. Usually I say, what's an encumbrance? People say liens and easements. Well, those are examples of encumbrances. What's the definition of an encumbrance? An encumbrance is anything that limits our use, title interest, or value. Use, title interest, or value is an encumbrance. What type of encumbrances would limit our use?
You just said
Easements?
Easements, not liens. Easements.
Easements.
Leases?
Would a lease
Yes.
limit my use? I buy that I can't even move into it. There's renters in there. You better believe that's an encumbrance. What else that limits my use? Zoning.
Zoning, yeah.
Setbacks. I can't build right on the street. I have to build in 20 feet or whatever. I can't build right on the side of my lot. I have to build in. All of these come into play. All of these come into play as far as an encumbrance go for use. Then we have anything that limits our title interest. Now those are liens. Liens limit our title interest. Liens do not limit our use. Whether I owe 100% or I have 100% paid off, my use is exactly the same. And title interest refers to liens. So anything that limits my use, which is zoning, homeowners associations, all those things are encumbrances that limit my use. I have encumbrances that limit my title interest. Those are liens. And then I have encumbrances that limit my value. You're next to a busy street. You're next to a railroad track. You've got something that limits your value from that. A lot of people argue that those aren't encumbrances. The heck they're not. If I'm buying a property, I want to know about these encumbrances. I want to know about this rendering plant that's 4 blocks away that's affecting me. You better believe it. So again, covenant against encumbrances, except those mentioned in the deed or title policy. Because every property has encumbrances of some kind. Everybody okay with that? I mentioned a city like Houston. Houston has no zoning. Houston has more people, far more people than the whole state of Colorado. No zoning in Houston. It was interesting. I was listening to this program the other day, this documentary. Houston, of course, is the #1 oil city in probably the world, but definitely the United States. Denver's #2. There's more people employed by the oil industry in Denver than any other city, even more so than Dallas. Isn't that something? And they're saying, Houston, you don't hear about Houston, you know, all the layoffs in the oil industry and everything. They say Houston is not hurting at all, for all intents and purposes, because in the last 10 years, there have been more homes built in the Houston area than the entire state of California. Isn't that something? And so what's happening in Colorado? Do you hear about a lot of layoffs in oil in Colorado? Probably not, because if there are any layoffs in Colorado, guess where they're going? They're building out there. We can't build these homes fast enough in Colorado right now. You can't go down a street in Denver without seeing something being built out there. So obviously, whatever layoffs there are in any industry in Denver, they're migrating to the building end of it. Kind of interesting how things happen. So again, we have covenant of season, covenant against encumbrances, covenant of quiet enjoyment. Remember, we heard that 2 other places. Where have we heard that at?
Leases.
In leases. What does it mean in a lease?
That you can keep your landlord out.
That we can keep our landlord out. Where else have we heard about quiet enjoyment? In the bundle of rights. And it means what it says in the bundle of rights, a right to quietly inhabit our property. And then we have this one. This one, covenant of quiet enjoyment in a general warranty deed, means something completely different again. It means that I will protect this interest that I'm transferring it to you. I will protect it against any third party that says they have an interest other than what I'm transferring to you. You can just put down protection from third party interest. And the way I will protect you is with the 4th covenant of further assurance. Not insurance, assurance. I'll provide whatever documents I have to. I'll even go to court to protect this interest that I'm transferring to you. Covenant of season, which means possession. Covenant against encumbrances, except those mentioned in the deed or title policy. Covenant of quiet enjoyment. Protection against third-party interests. And I will protect that with a covenant of further assurance. I'll provide whatever documents I have to. I'll even go to court to protect you. And the last one is the biggie. Warranty forever. You warranty it forever in the past, which subsequently warrants it forever in the future. What is it? What are we talking about here? Title. We're not talking about the property itself, are we? This is the title, guys. Remember, we talk about title insurance every session until you're sick of hearing about it. I don't care. You've got to know what title is all about, guys. You get a deed to your property, that may or may not tell you what you bought. But a deed with a title insurance policy, you got a pretty good idea what you just purchased. So, when you're looking at a deed, very seldom does it say what kind of deed it does. The only type of deed that always says what kind of deed it is a quitclaim deed. Most warranty deeds just have warranty up there. And you've got to look through it and see which promises are in there. You know which promises they always have in a general warranty deed? That warranty forever. Sometimes that's the only one they really mention. They might mention season. They might mention, again, the covenant of warranty forever. And as soon as you see that, you know it's a general warranty deed. And a lot of times, those are the only 2 they're going to have, is the covenant of season and the covenant of warranty forever. The other ones are understood. They're still a part of that deed. Now, this covenant of warranty forever, they go back to a root date. Write that down. A root date. Usually 40 years.
For which one?
On the covenant of warranty forever. They warranty it forever in the past. Well, what's forever? Well, in most states it's 40 years. They go back 40 years. They warranty it 40 years in the past, which warrants it forever in the future for those owners.
40 years in the past?
They go back, yes. They go back 40 years. That's the warranty forever. Let's read this paragraph underneath that general warranty deed. The first two covenants relate to the past and generally do not run with the land, meaning that only the current grantee may sue the grantor for a breach. The last three covenants protect against future defects and are said to run with the land, allowing any subsequent grantee to seek remedy for breach against any previous grantor, like covenants of season, peaceful possession, freedom from encumbrances, and warranty contained in any conveyance of real estate, or any interest therein, shall run with the premises and inure to the benefit of all subsequent purchasers and encumbrances. That's why you want a general warranty deed when you buy a property. You want to give a special warranty deed when you sell it. Is that a double standard? Yes, it is. You guys paid the price to know the difference. You have the right to do that. Most people have no clue that that's what types of deeds you should use. Let's go to the top of page 9-6 and talk about a bargain and sale deed. Now, we used to use these in foreclosures in Colorado to a point. We really don't see one anymore. You'll probably go your whole career and never run into a bargain and sale deed unless you go outside of Colorado. But they say here the bargain and sale deeds can take the place of quitclaim deeds and whatever, and they can, because they only have implied warranties. Again, bargain and sale deeds only have implied warranties. One way to remember it, it's a bunch of BS. Right? Bargain and sale deeds only have implied warranties, may not have any at all. And then, of course, your quitclaim deed. Look how it's spelled again, guys. It's spelled with a T. You're quitting your claim. Remember on these crooks, I talked about these investment groups. They're not all crooks, okay? Some are legitimate, I think. Anyway, but what they do on these quitclaim deeds is just get a quitclaim deed from the people. And most people say, I'm going to work with you, and I'm the guru of this industry. Just give me a quitclaim deed on your property so I have control over how to market your property for you, whatever. They're actually doing that out there. Can
My
you
dad
imagine?
did that for my brother's house.
Pardon me?
My dad had a home and he moved into another house, and my little brother moved into that house and he did the quitclaim deed for him.
Yes, this is very legitimate. You use quitclaim deeds for family members. For family members. I want to give my daughter a property. I'll do it with a quitclaim deed. Let's say that, I'll tell you a story. We had, several years ago, I had this one couple. They'd only been married a couple of years. They were in their 50s. And he owned 4 properties, he owned 5 properties. She owned 4 properties. And so after a couple of years, we're talking about this, and I said, really? So you guys have been married for a couple, 3 years now. What have you done with those properties? And they said, nothing. You know, those 4 properties are hers, the 5 properties are mine. That's just how we did it. Say, oh, no. Remember, in Colorado, we're a common law state in Colorado. When you stand up there at the aisle and say, I do, you're actually saying, I do give you half of everything I own. But it's a two-way street. You're getting half of the other people's stuff, too. So what's the moral of this? Don't get married or marry correctly. One of the two, right? And so what happened, I said, so what are you guys doing with this house? With your houses? They said, nothing, I said, what you need to do, because once you sell them, you're going to have a cloud on that title. You've got to, because she owns half of his 5, he owns half of her 4. So I gave him 9 quitclaim deeds. I always have quitclaim deeds on my desk. And it takes 5 minutes to fill. It didn't even take 5 minutes to get all of them filled out.
Well, what if they have a prenup?
What if they have a prenup? Well, that's different.
Because they have so many assets.
They might have had a prenup, and that could change everything in a prenup, okay? But this isn't the case, okay? They went in there, no prenup, nothing. And so now, I gave him 9 quitclaim deeds. So what he did is he quitclaimed half of his interest in his 5 houses to her. She quitclaimed half of her 4 houses to him. Now, when those properties are sold, it's very clean. The title company will go look at those county records and say, oh, look at this, yeah. She's on both properties, he's on both properties, everything's very clean. What if he would have sold one of those properties, or vice versa? Say he sold one of them. Then a couple years later, they get a divorce.
She can come back.
And well, yeah, and the attorney says, what about the profit he made on that house he sold a couple years ago? Well, that was his house before he got married. I don't have any claim on that.
Yes, you do.
Oh, yeah. You sure as heck do. You better believe it.
Jim, is a quick claim deed like when you're buying a house, you get a say general warranty or special warranty. The moment while you're still in the closing room, it's active before it's recorded. Is that true with a quit claim deed as well? The moment it's signed, it is active and legal?
The question is, what if you get a quit claim deed as a closing? Is that active and
No,
legal?
not really a closing. I guess I was using the at closing as an example. You've told us that when you buy a home, before you walk out of that room, it's done.
You own the property.
It has to be recorded yet, or will be recorded. Is a quit claim deed signed in your office or wherever, is it also enforced the moment it's signed, or must it be recorded?
Well, let's talk about this. I had a lady in class one time, and she was very concerned when we were talking about this because she bought this $1.5 million house from a developer, and he gave her a quitclaim deed. And I said, really? I said, did you get a title policy? She said, yeah. Do you need a title policy on a new home that's never been sold before?
Yes.
Yeah.
Because the land's been
The
there.
land's been sold.
The
Oh
house
yeah,
is
you
just
better
like-
believe it. Yeah, you always never ever buy a property or allow your clients to buy a property without a title policy. And so I said, well, if you've got a title policy, you're probably fine. You're probably fine. But I guarantee you, if she would not have taken this class, she would have when it went to sell her home, this all-knowing real estate broker would have come into her house and committed her to give a general warranty deed, when all she got was a quitclaim deed when she bought the place. You know, that's legitimate, but wow, what kind of deed is she going to use? Special warranty deed. Sure, you bet. You bet. And so, how come I didn't tell her, well, go back to that developer and have him give you a general warranty deed?
It's already done. He can't.
He doesn't own it anymore. He can't give her a general warranty deed, right?
It's over time.
Right. Now, if this should happen, something like that, and she's freaking out, I said, well, you got a title policy, and a quitclaim deed transfers all the ownership interest that developer had. He just didn't go with any promises.
And it's executed at time of signature?
Yeah, it's executed at time of signature. You bet it is. Well, not a signature, but delivery and acceptance when all the signatures are done. You bet, just like any other deed. Which is the strongest of all deeds? General warranty deed. Which deed transfers the most amount of ownership interest?
General. Oh, they all are.
They all transfer exactly the same. One more time.
Ownership interest.
Which one? Which deed is the strongest of all deeds? A general warranty deed. Which deed transfers the most amount of ownership interest? They all transfer exactly the same amount. Whether you give them a general warranty deed or a quitclaim deed, you're still transferring all the ownership interest that you have. It's just that some of them have promises.
Sorry, Peter.
So,
That's a trick question on the exam, is it?
expect to see that on the exam. You better believe it. No, it's a very legitimate question on the exam.
That sounds like a trick question to me.
When you're in there talking to people about taking a listing on their house, you're gonna have all their paperwork there. You're gonna see what kind of deed they have. Would that be cool when you're sitting there talking to them about what that deed is all about?
They all transfer the same amount of
Ownership interest.
only the general has the most protection
For who?
for them.
For the
Buyer.
For the buyer has the most amount of protection with the general warranty deed.
Yes.
Which deed do I always want to give if I have a choice?
Special warranty.
A quitclaim.
Oh, quitclaim.
If I have a choice, but I'm probably not going to get away with giving a quitclaim because nobody even knows what it is, really. But they saw that Western last week, and they know, you know. And so I'm going to give a special warranty deed. I'm going to get a general warranty deed. Okay, let's look at page 9-6, guys, and look at the elements of a deed. These are the same thing as the elements of a contract, elements of a lease. Once you know one list, you know them all pretty much. Bottom of page 9-6. It has to be a written instrument. Top of page 9-7. You have to have the parties, the grantor and grantee. You have to have recital of consideration. What the heck's definition of consideration?
Something that exchanges between the two of you.
Yeah, something of value, consideration, something of value. And then you have to have words of conveyance. You have to show an intent to convey. An intent to convey, words of conveyance or quit claim. Then you have description of the property. We use what? What do we hang our hats on?
Legal description.
Legal description, not the address. Why can't we just use the address and forget about it?
Change the
You can change the address, you can't change the legal description. Page 9-8, you have to have the signature. Remember, only the grantor signs the deed. The grantee does not sign it. There's not even a place for them to sign it. They merely accept it. So we have the signature of the grantor, delivery and acceptance. That's when that deed transfers, when there's been delivery and acceptance. And where does that happen? Does it happen when you record it?
No.
Happens when you
Solidify
sign.
and sign.
It happens at that closing table. You walk out of that room owning that property. Whether it's been recorded or not. No state has a recording requirement because you don't have to record it. Because the transfer is in that closing room. Why do you record it then?
So that there's general.
It's like a public advertisement, I forget what you refer to it, but.
Anybody remember the term? We're giving.
Thinking.
Due diligence.
The treasury lady?
What's that? What'd you say, Sheridan?
Public notification.
No, I still haven't heard it yet.
I'm trying.
No,
It
it's
begins with a C.
Say
Constructive
the question
notice.
again?
Conveyance.
Say it again, Steve.
Constructive
Steve
notice.
nailed it. Constructive
he's
notice.
nailed it.
Constructive
Good job.
notice.
Constructive notice. Notice that
Constructive, I didn't know.
nobody on the planet can say they don't know I own this place.
And that's,
Constructive notice.
okay.
Recorded.
There's two ways to give constructive notice. What if I don't record it and 5 years from now I go to sell the property, the title company goes and looks at the public records and go, look at that, this clown's not even on title, what's he trying to pull? They'll come and knock on my door and say, did you get a deed? And I'll show up and say, yes I did. So there's two ways we can give constructive notice. We can record the deed or take possession. Or take possession. Either way, we're giving constructive notice of our ownership interest. We own it when we leave that closing room, before we leave the closing room. But when we record it, we're letting the whole world know that it happened. That's why that question coming at you, when do we have a pretty good presumption of delivery and acceptance? When it's been recorded. When it's been recorded. You're going to have that question. That's probably the question I get more questions on from students than any other question on our finals, is that one. Hopefully you guys understand what I just said. And if not, you're going to have that question in the finals and other parts of this course. And hopefully a light will come on when you see it. Then we have exceptions and restrictions. I'm selling you my property. It's a little ranch or whatever, but I'm keeping the mineral rights. I'm exempting something or restricting something. I'm not selling you everything. Top of the next page. Warranties and covenants. Remember, there's only two deeds that have warranties. There's only two deeds that have covenants. Special warranty deed and general warranty deed. Now, a bargain and sale deed may have covenants, but they're only implied. Then we have a date, which is just a benchmark date. Contract dated such and such. An acknowledgement. Let's read this acknowledgement. Big star by this acknowledgement here. An acknowledgement is a declaration made by a person, a grantor to a notary public, or other authorized official, that the grantor executed the instrument and did so freely and voluntarily. Yeah. Freely. An acknowledgement is a notary, is what an acknowledgement is. In Colorado, there are no requirements for acknowledgement. In some states, you can't record a deed unless it's been acknowledged. Not in Colorado. Doesn't have to be acknowledged or recorded. Then, look at number 12 down here, the recording, what we just talked about. Here it is in black and white, guys. A deed is valid even if it's not recorded. The wording of the Colorado recording statute is permissive, may be recorded, rather than must be recorded. Recording offers a twofold benefit. It protects the innocent purchaser or encumbrancer. Who's an encumbrancer?
The person that's putting the stipulation on the property?
A lender would be an encumbrancer, as an example. Right? Again, it protects the innocent purchaser or encumbrancer from acting in ignorance of an unrecorded instrument. and it provides constructive notice, there it is, of legally conclusive presumption that all persons have knowledge of recorded instruments. It is in the grantor's best interest to record the deed immediately. Lack of acknowledgement does not invalidate constructive notice. A recorded deed that is not acknowledged still serves notice to subsequent purchasers. Good information there, guys. So again, how else did you know deeds? I hope you all get to know them as well as I'm saying it up here. Know it that well. It'll serve you very well out there. Whenever you're at a meeting or something, you know, you're at a dinner party, you're out there doing something with some friends or whatever, and you know, you're all standing around having drinks or whatever, and you walk up to somebody and say, "So, do you have a mortgage on your property?" They say, "Yeah, I sure do." You say, "No, you really don't. You really don't have a mortgage." Why?
Because the mortgage is the property.
Because nobody has a mortgage. In Colorado, we don't even use mortgages. We use deeds of trust or trust deeds. Same thing. Deeds of trust or trust deeds. One more time. We don't use mortgages in Colorado. We use deeds of trust or trust deeds. Some states use mortgages. The mortgage is not the money. You ask 100 people if the mortgage is the money, 99 of them will say, "Well, of course it is. Mortgage is the money." No, it's not. It's the property. Then what's the money?
Promissory note.
The promissory note is the money. Your promise to pay is the money. Then you have your security for that money, which is our deed of trust. And you give that to the bank, and the bank...
No, it's a deed.
What did I say?
You said deed of trust.
Yes, a deed of trust. You sign the deed, you sign the promissory note, and then you give the deed of trust to the lender as security for that promissory note. Yes, you sign the
And
deed of
what's the
trust,
deed?
and the
No,
deed.
the deed is the
Okay, let's
property.
back up.
No,
I signed the promissory note. That's my promise to pay. That my wife and I do this. We both individually and jointly agree to pay it. So they can go after either one of us individually for payment.
Don't you also refer to that as evidence of the debt?
This is the evidence of the debt. This is the money, the promissory note. That's the first thing we sign. Then we sign the deed of trust after that, which is the security for that. And it goes to the lender. In Colorado, the lender then takes that deed of trust and does what with it?
Records it?
No, you probably don't. We'll cover that in another couple sessions here, okay? They give it to the public trustee to hold. Public trustee to hold. Every county in Colorado has a public trustee who's appointed by the governor, except in Denver where they're elected. And that public trustee holds that deed of trust for the benefit of the lender. Because in every trust there's three parties. There's the trustor. I bought the property. I'm the trustor. I start the trust. We have the public trustee who holds that deed of trust for the benefit of the lender. Because the lender has the benefit, the lender is the beneficiary. Beneficiary. I'm the trustor. I start the deal. The public trustee is the trustee. Almost too easy. Public trustee is the trustee who holds it for the benefit of the lender, and because the lender is the beneficiary of, is the one benefiting from that, he's the beneficiary. Trustor, trustee, beneficiary. How are we doing?
Do we have a presenter today?
Presenter today. I thought.
Well, the time is starting, you, I guess.
Let's get some lunch going. Huh? That's funny. So we have again. You guys. And so we have what? Now we have the promissory note. We have the deed of trust.
I mean the deed.
And then the biggie is the deed. Now the deed comes into play. That deed's not going to appear until those other two issues are taken care of. And then what happens? The grantor will give the deed to the grantee, delivery and acceptance. Okay? So those are the main parts. And what's the other one that cements it all together? The title policy. So you got the four main spokes of the wheel, guys. You've got your promissory note, your deed of trust, your deed, and then the title insurance. Okay? Everything else is just detail. It really is to a great extent, and be able to sit down and explain this to people, wow. Not too many people know this, that it works that way, especially people coming in from other states where they use mortgages. When we get into lending, we talk about this. Before 2008, when all the lenders were licensed in Colorado, I shouldn't say all the lenders, only the mortgage brokers were licensed in Colorado. Bankers, lenders from credit unions, none of those people are licensed. Isn't that something? Only mortgage brokers are licensed in Colorado. Before they were licensed in 2008, it's estimated that 42% of all loans were done by out-of-state lenders. I lost my license in Florida. Well, that's okay. I'll just go do some business in Colorado. They don't have any license requirements. And almost all of these loans that were done back then, they gave the people in Colorado a mortgage instead of a deed of trust. We're going to find out here in another couple sessions that if they did that, it was a free house. It was a free house. Because these lenders can't foreclose on that house. They have to go through the courts to foreclose. It takes about 2 years and $10,000. And they're not going to do that if they're an out-of-state lender. They don't even know this is going on. There are probably thousands of homes still in Colorado that if people knew it, it'd be a free house. Because they have a mortgage instead of a deed of trust.
So that's why.
How do you cherry that in?
Hold on. What's that? Let me get Moses first.
Yeah,
Go ahead, Moses.
So that's why every once in a while you'll hear about somebody who got foreclosed on and they're still in their house 2-3 years later.
Sometimes.
Where they get foreclosed on and they're still in their house 2 or 3 years later, that's for a different reason.
That's different.
Okay, that's usually for a different reason. Right now, there's about 790 banks in Colorado, in the United States, Colorado. Yeah, the United States are on the verge of getting shut down by the government. And what's happening? So I'm one of those banks, and what's happening is I got one of my people who have a house, and they're $6,000 behind in their payments. Well, if I start to foreclose on this guy, every foreclosure costs me about $60,000. So I can foreclose on the guy and show a $60,000 hit, or just let him write it out and show a $6,000 hit. And that's why people can stay in their home for a year or two before a bank will ever drop the hammer on a foreclosure. Hope that makes sense. That instead of doing it that way, Moses, more so. Now, after the foreclosure happens, they're out of there. They have to get out of there. We'll talk about that again in a couple more sessions.
But if they own their house because it's a mortgage, they just never get foreclosed.
If they own their home because they have a mortgage instead of a deed of trust, we'll find out in, let's say, in a couple more sessions, guys, they have to go through the courts to foreclose. This public trustee can start an immediate foreclosure action if they're holding the deed of trust. This mortgage doesn't apply to the public trustee. And because of that, every foreclosure in Colorado has to be judicial through the courts. That's why.
So where do we look for that language? Everybody wants to know if you're a homeowner, where do you find that language?
Look and see if you have a deed or a deed of trust. See if you have a deed of trust or if you have a mortgage. See if you have a promissory note. Let's see what the structure is. You want to bring in your paperwork? Let's take literally 15 seconds and see what you have. It's that easy to find out. And I'm serious, guys. You want to bring in your paperwork? Bring it on in. I'm glad to take a minute and look at it. Anyway, in kind of an interesting session. A lot of meat in this session. A lot of stuff you're going to use. Okay, what are the 3 ways we take title in Colorado?
Joint tenancy, tenancy in common, tenancy.
Good. Joint tenancy, tenancy in common, and severalty. Those are the only 3 ways we can take title in Colorado. And the 4 types of deeds? General warranty deed, special warranty deed, bargain and sale, and quitclaim. And we'll talk about the different types of quitclaim deeds. If someone dies in testate, what's that mean? Without a will. Someone dies in testate and they have no heirs. They have no heirs. What type of deed will bring any property out of probate in that situation?
Special representative deed.
If they don't have any heirs, okay, and what type of property will bring it out of a probate action? There's 2 different issues. Okay, they have no heirs, and there's some property there. There has to be a certain type of deed that brings it out. Or what if they die intestate and they do have heirs? 2 different types. We've got a what they do have heirs, if they do have heirs, and it's going to be what? A personal representative's deed that's going to bring it out. If I have a will, what if I die testate with a will? What type of deed brings the property out of a probate action? Who do I appoint in my will to take care of everything?
Administrator.
No,
No.
the baby thing.
Who do you appoint in a
Surrogate.
will?
Surrogate.
Surrogate.
No.
No? Oh, you appoint
Who do you appoint? You appoint an
executor.
very good, an executor in the will. So he takes an executive's deed. Will pull a property out of a probate action if you die testate with heirs. If you die intestate, if you die intestate with heirs, it's going to be a personal representative's deed that brings it out.
So,
All right.
so with that, with no heirs, it's,
You have again. You die. You don't have a will, and you have no heirs. Or you have heir. You die without a will. It's going to be a personal representative's deed that's going to pull it out.
With heirs.
If you do have heirs, and you die with a will, it's going to be an executor's deed because you appointed an executor to take care of your assets and everything.
So they're both intestate with
Yeah.
heirs.
confusing.
All right,
Oh, yeah,
intestate
this-
with heirs is which one?
Okay, again, you die intestate without a will, but you have heirs.
Yes.
There's going to be a personal representative's deed that's going to pull it out. You're going to run into this stuff, guys. This isn't something I'll never run into it anyway. The heck, you're not going to run into it. I had one deal last year. It was a personal representative's deed, and I didn't know it.
Oh,
And the other broker said, got his attorney on the line and said, "This attorney has something to tell you." Says it, and he said, "Yeah, this property's coming out of a probate action, and what we use really is called a personal rep." He's talking to me like I'm a rookie. I'm going, really? I didn't know it was coming out of probate. I would have put down personal representative's deed. I was kind of insulted, and I thought, get off your ego, Trev. Let's just get this deal done, you know. And that's what you have to do sometimes.
estate with heirs.
But that's how people talk to us initially. They treat us like we don't know squat out there,
Without is which
and
one
most
then?
of us don't. So again, and what property what deed takes a property out of a probate action? When you die testate with heirs. An executor's deed. An executor's deed. Yeah, executor's deed, a personal representative's deed.
Okay, so without.
So executor deeds is,
An executor's deed is where you die with a will because you appointed an executor, didn't you? That's why it's called an executor's deed. What type of deed would you get in a tax sale if you got a tax sale on a foreclosed piece of property in a tax sale? A treasurer's deed, because that's the treasurer's put the lien on the property, right? A treasurer's deed. These are all quitclaim deeds, guys. They're just fancy names for quitclaim deeds. Okay. That is the end of lesson 5. Let's go ahead and take a break.